that the stream is alive and well on all of the various different platforms on which we stream, which of course are YouTube and Facebook and Periscope. YouTube always takes a little bit longer than some of the others to get going. So let's check, make sure we're live, and we are. So let's get started. Hello, my friends. Welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful, sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. We help them navigate through the criminal justice system. And over our time in practice, we have seen a lot of problems with that very justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges who are not particularly interested in a thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes they have a difficult time doing so themselves. And that's why we started this program called Watching the Watchers, so that together we can shine that big, beautiful spotlight of accountability and transparency back down upon that very system, with the hopes of encouraging some meaningful change. That's why we're so grateful that you are here and with us today, because we've got a lot to get into. We have some new information on the Ghislaine Maxwell case. We haven't talked about this case in a long time, but we have a new update. There was an order that was just released yesterday from a judge that says Ghislaine is not going to be getting out of custody anytime soon. If you're not familiar with Ghislaine Maxwell, she was really Jeffrey Epstein's number two. Jeffrey Epstein, of course, the sort of world-renowned sex trafficker, allegedly, who didn't get his day in court because he passed away unexpectedly. Well, Ghislaine Maxwell is in custody, and her attorneys, prior to the Christmas Day holiday break, they were trying to get her out of custody so that she could go home and be with her family during the holidays. Judge just said, sorry, not going to happen. So we have that order. Want to talk a little bit about that. Been a lot of kerfuffle going on in our Congress, as is usually the case. We spent some time talking about the new bills that have been put forth in front of the House and in front of the Senate that are going to just balloon the federal budget even further. We're talking about the Military Authorization Appropriations Act. We're also talking about the COVID-19 relief and just the bigger omnibus bill that includes just $2.4 trillion of spending. There's been back and forth going on there, right? We saw that it was passed by both houses. Donald Trump said, I'm not going to sign that unless you increase those payments from $600 to $2,000. And they sent that back to the House. The House did something. The Senate did something. Mitch McConnell just did something else this afternoon. So we want to break that down as well. And then lastly, we're going to finish with a Second Circuit Court of Appeals opinion that involves religious freedom. That's right. Andrew Cuomo from New York City, the governor out there, passed an ordinance, an executive order that said that certain religious institutions can't have a certain number of people in their congregations when they're worshiping. And the Second Circuit Court of Appeals just said, no, that's unconstitutional. So I want to dive into a little bit more of that. We have the opinion, break that down. We're going to get into a little bit of a constitutional questions here. What is strict scrutiny? What is rational basis? So there's a lot of meat there. Want to make sure that you are along with us as we go through that. Now's a good time to invite you to subscribe to the channel if you're not already a part of what we do here. We go live at this time every day of the week. If you're not familiar with the program, the way the format works is I'm going to spend about the next 45 minutes, maybe an hour, going through some of the material that I just outlined. The slides that I go through are all available in our Discord server. That's where we chat before and after the show. Copy of the slides will go in there after the broadcast ends. You can also get a copy of my book in there. So a couple incentives to head on over there and chat with us before and after the program. Otherwise, let's just get started. Let's dive into it. We're getting started with Ghislaine Maxwell. Ghislaine Maxwell, as we know, has been really sort of a miss. She hasn't been around for a long period of time. She was just recently, this last year, was picked up. Remember, Jeffrey Epstein was arrested. He was sort of interrogated, investigated, and then he ended up dying. Allegedly, he killed himself. Many people are saying that Epstein didn't, in fact, kill himself, but there's not a lot of evidence to support that. There was a lot of weird things happening during his death. I think the security footage at the prison facility went down. A couple of guards were asleep at the wheel, and just by happen chance, he is now dead. And so many people are looking at Ghislaine Maxwell, who was his number two. I mean, literally helping, allegedly, to help groom some of these women that were going to be used by by Jeffrey Epstein. And in some allegations, Ghislaine Maxwell was participating in some of these sexual, escapades with underage individuals in sort of all different parts of the world, in Epstein's private island and in New York. They had a place over in Europe and so on. And so now that Jeffrey Epstein is dead, many people are looking to Ghislaine Maxwell and they're saying, this is it. Like, we have to keep this woman in custody alive. Nothing can happen to her, because if something does, we may lose the entire story, right? If Epstein's dead and his number two is dead, well, what about all of the ball of yarn that many of us have been really sort of salivating over to see who's involved in this thing? Who's involved in this international sex trafficking ring? Because Jeffrey Epstein palled around with a lot of very high profile, very well-renowned individuals, big tech people, major politicians, foreign leaders, everybody was involved with the guy. And so everybody's sort of on high alert, wondering what's going to happen with Ghislaine Maxwell. Prior to the holiday, she was really doing her best to get out of custody. This next article comes from Adam Classfield over at lawandcrime.com. If you're interested in legal news, he does a pretty good job over there of just, aggregating a lot of the legal stories. So I'd encourage you to go check them out. Let's take a look at what he wrote. This was on December 4th. So I want to show you sort of some of the history that we had to go through in order to get here. And then we're going to show you the actual order from the judge, which is very interesting. So Ghislaine Maxwell, she wanted to be home for the holidays. She filed a renewed bail application. So this article says that last month, which would have been in November, Maxwell was placed under quarantine by officials inside the Brooklyn Metro Detention Center after a staffer in her area of the jail contracted COVID-19. And that was sort of the first little bit of rubbing your eyeballs going, are you kidding me right now? Jeffrey Epstein's dead. Now Ghislaine Maxwell has COVID, or potentially could be exposed to COVID. Wouldn't that be convenient if she passed away? Well, that didn't happen. Specifically, this article says on November 18th, the defendant was tested for COVID-19 using a rapid test. It was negative. The U.S. Assistant Attorney disclosed 5 days after the incident. That same day, she was placed in quarantine, so they're doing everything they can to keep her not exposed. Her attorney, Bobby Sternheim, complained shortly after she was put into quarantine. He says she's being treated worse than a terrorist. Ms. Maxwell, he says in a quote, is a nonviolent, exemplary pretrial detainee with no criminal history, no history of violence, no history of mental health issues or suicidal ideation. He says she is overmanaged under conditions more restrictive than inmates housed in 10 South, the most restrictive unit in the MCC, or individuals convicted of terrorism, capital murder, incarcerated at Florence, which is a supermax. It's the most restrictive facility operated by the Bureau of Prisons. And so he was pretty upset about that. Now, there is a good reason for that in my mind. It's because this is a extremely high-profile individual, right? We want to make sure that nothing happens to her because she's kind of the only remaining puzzle piece that's left. So if something happens, right, if she gets Jeffrey Epsteined, might be the end of the case, literally. And so, they're on high alert. I understand her attorney, who's a defense attorney, who's, one of my people, understand the case that he is trying to make here. And you can easily sort of compare and contrast the two situations, right? Ghislaine Maxwell allegedly was just involved in some underage sex trafficking. There are other people who've blown up buildings and murdered people and raped people, definitively, and they're saying that she's being treated worse than them. I think that's probably an unfair characterization of it, but a defense attorney has to do what a defense attorney has to do. And this article goes on. It says Maxwell's legal team asked for another chance to let their client out on bail, having lost a similar effort back in July. So they already tried this. Back then, prosecutors depicted Maxwell as living a life on the lam, traveling frequently with 3 passports, owning more than a dozen bank accounts, traveling under assumed alter egos, and entering into a secret marriage that she would not disclose to prosecutors. So we've been through this before. In July, Ms. Maxwell's attorneys said, we want to get her out of custody. We saw some of those headlines, but we haven't seen many of the formal documents that have been filed because almost all of this stuff is under seal. We're going to show you what that looks like here in a little bit. But we do have a letter from Ms. Maxwell's defense team talking to the court, asking them to give her another opportunity to try to get out of custody. So when we're talking about a defendant posting bail, let's break that down and frame that out a little bit. So let's say, for example, you're a first offense individual. You got charged with a domestic violence type of case or a DUI case, something sort of benign, and you've got no criminal history. You live in the state where you were arrested. You didn't do anything violent, and so you get arrested and booked into jail. Well, the next morning or maybe even that same night, you should see a judge, and the judge will tell you what you've been charged with, what the nature of those charges are, what the maximum penalty is, basically doing what's called an arraignment, and then decide what are your release conditions? Should we let you out of custody or not? Or if we are going to let you out of custody, are there certain things that we want to put in place as restrictions to make sure that you come back to court, right? Because if you've been charged with a crime, now you have a court date in 30 days, we want to make sure that you show up to that court date. We don't want to just say, all right, well, yeah, leave the country, go someplace and we'll never see you again. We want people to be engaged with the judicial system. And so in that situation, a judge might look at you and say, okay, well, look, you are not a flight risk, right? You live in your home state. You don't have any criminal record. You're not a danger to the community. You've got a job here. Your family's here. You've got a lot of assets here. And so the likelihood of you just picking up and moving to a non-extradition country where we're never going to find you again is probably pretty low, right? Your whole life is here. And the courts will recognize that. Now, if you've done something very serious, in Arizona, for example, there are certain offenses like sexual assault or rape where you just can't get out of custody. I mean, if you're charged with a crime like that and you've never had a criminal record or you've never been in trouble before in your whole life, it's still hard to get out of custody. A judge is not going to let you out because they consider you to be a danger to the community. You've done something so egregious that the way that our laws are written here, that even though you haven't been convicted of anything, you haven't been found guilty of any crime, you're still innocent until proven otherwise, they're still not going to let you out of custody because they're just weighing the balance, right? They're saying, well, this person, the default that we're going to give people more freedom is superseded by the potential severity of the harm. So the harm outweighs the inclination to let people out of custody. And we're kind of going through that same conversation round and around again as it pertains to Ghislaine Maxwell. And so the first time that the attorneys presented their evidence, I think they proposed something like a $31 million bond, which she would have to post, and don't quote me on that number, but it was in the tens of millions, I believe. So they were saying, look, she's going to post all of this money with the government. You guys can hold on to that. That's going to secure her appearance. So we're going to let her back out, right? But she's going to come back to court because you're hanging on to collateral. You've got $31 million or whatever that number was, a big fat number. So obviously she's not going to leave because if she does, then the government's just going to keep that $30 million. And so it's sort of, that's the kind of game that we're playing. It's collateral in order to get somebody out of custody. Well, back in earlier this year, that was already denied. So they already made those efforts, those motions. Now we're coming back around for a second time. And what the defense team is doing is they're being extremely aggressive, which of course they should. They're probably, excellent at this type of work. And I don't know them personally or know much about them other than the fact that probably very expensive, probably very good. So what we're talking about here is a renewed application. So they're requesting the court to let Ghislaine Maxwell out again. They filed this on December 4th. This was a letter over to the U.S. District Court. This is for the Southern District of New York. You can see here one of Ghislaine's attorneys is Mark Cohen over from Cohen and Gresser LLP. That's on the 21st floor in New York, New York. So, probably a very, very established, reputable law firm. And they're saying, per the court's orders, we have conferred, the numerous parties have, and this is the proposed scheduling order to determine whether or not we're going to grant Ghislaine bail, whether she's going to be allowed to get out of custody. The defense is saying that they're requesting that the hearings take place before the holidays. So they wanted the defense submission to be by December 7th, the government to respond by the 16th, defense reply by the 18th. They wanted the hearing on the 21st. They were hoping to get her out of custody before that time. Obviously, that did not happen because we just got an order yesterday, late yesterday, saying that this has been denied. But here's what they were asking for. So they were saying the defense will send our submission to the court under seal on the dates and will include a proposed redacted version that is going to be submitted onto the court's docket. We asked that the court order the government to do the same thing. They know that they had a 25-page limit on civil motions, but they asked the court to grant them 40 pages for their motion, and they wanted to give the government the same opportunity to respond with the same page limit. So, they really kind of filing a beefy motion, and they wanted to get this all done before Christmas, but that just didn't happen. And we see an order was released from the judge yesterday. This was in the case of U.S. versus Ghislaine Maxwell. We can see the order here, and it was electronically filed yesterday on 12/28. out of the United States District Court for the Southern District of New York. It's a 2-page order. I'm going to go through it relatively quickly. It says here, on December 8th, Ghislaine Maxwell filed a renewed motion for release on bail in an opinion and an order concurrently filed under temporary seal. The court denies the defendant's motion. All right, so what does that mean? Well, the order that we're reading right now is just sort of the nuts and bolts. They're just telling us whether the judge is going to grant it or deny it. It's 2 pages. There is a little bit of information we can glean from it, but this is not the full order. The judge presumably has a much larger order that has a lot more information in it, but as we're going to see, that concurrent order is filed under seal, which has been the trend, the pattern in this case since the outset, right? Everything has been under seal, which means we don't have access to it. We can't see it. It's all being protected. The court has deemed that this information is not good to be out in the public, and it could be for a number of reasons. It could be that it implicates other people. It could be that it undermines the government's investigation. It could be, just sensitive material that is attorney-client sort of protected information. I mean, there's a million reasons why the judge wouldn't allow this stuff to come out, but they are looking to give more information. We're going to see that the judge says, listen, this order right here is the nuts and bolts of it. I'm going to be releasing a bigger order that explains more details, and the judge is giving both sides an opportunity, just a couple days, to object to what should be included or not included in the full order. So this is a little bit of a preview, a little bit of a snapshot, and in this court, they're going to give both parties, both sides, Ghislaine's team and the prosecutors, some opportunity to decide what they want to object to keep out of the public light. So pretty interesting stuff. They're saying here, the order says, in light of the fact that the opinion includes potentially confidential information that should not be filed on the public docket, the court will permit the parties 48 hours, so just 2 days from yesterday, so we're looking at tomorrow at some point in time, to propose any redactions to the court's opinion and the order, and to justify those redactions by reference to the Second Circuit Court's decision in this case. It says, after determining which, if any, portions of the opinion and the order should be redacted, the court will file the opinion and order on the public docket. So should be looking for that tomorrow or Thursday or Friday. I mean, it should be there. We should have a full order, and we're going to want to review that as well and see if there's anything that's a little bit more juicy than what we get in this snapshot. But the judge goes on and says, even though, this is not the full thing, there are a couple points that we want to talk about. This order provides the bottom line of the court's resolution. On July 14, 2020, this court conducted an extensive bail hearing and determined that pretrial detention was warranted because the no conditions or set of conditions could reasonably, I think there's a typo there, because no conditions or set of conditions could reasonably assure the defendant's appearance at future proceedings. So again, what they're saying here is that she can post whatever she wants. I mean, she could post $100 million. She could say that, she can wear an ankle monitor. She could say she's going to be on home detention. That's all great. She's probably still going to bail. There's nothing that we can do because this person has so much means and is so plugged into the sort of power structure that they've been escaping liability for literally decades. And if they get pulled out of custody, the likelihood that they're going to come back is almost non-existent. The judge says, under U.S. Code 3142, a bail hearing may be reopened if the court finds that, quote, information exists that was not known to the movement at the time of the hearing and that has a material bearing on the issue whether there are conditions of release that will reasonably assure the appearance of such a person as required. This court concludes that none of the new information that the defendant presented in support of her application has a material bearing on the court's determination that she poses a flight risk. So what this judge is saying is that, listen, we already had a hearing back on July 14th. It was very extensive. Under the U.S. Code, the rules say that even though we had that hearing, if you defendant, if you, Ghislaine, and your team, if you come to us and you say we've got new information, the court may be inclined to have a second bail hearing. They may be inclined to reopen that and consider the new information because stuff changes all the time, right? Think about a situation, Ghislaine has cancer, right? It's terminal cancer. And now the court says, all right, well, we're going to let her out and we're going to let her go spend some time with her family. It's a pretty material change in circumstances, and the judge might show some leniency or some heart in that type of a situation. It's just one example of a material change in circumstances or a material change in information. And so that does happen from time to time. But what they're saying here is that, even though we're going to reopen it, we heard all of the new evidence that Ghislaine and her defense team proffered and doesn't pass muster. Doesn't lead us to believe that she should be released. Furthermore, the judge continues, for substantially the same reasons as the court determined that detention was warranted in the initial bail hearing, the court again concludes that no conditions of release can reasonably assure the defendant's appearance at future proceedings. In reaching that conclusion, the court considers the nature and circumstances of the offenses charged, so that's one prong, the weight of the evidence against the defendant, another one, the history and characteristics of the defendant, number three, and the nature and seriousness of the danger that the defendant's release would pose. So sort of a four-pronged test there. Then they cite the U.S. Code once again. The government does not contend that the defendant poses a danger to the community. Right? So they're just saying, yeah, she's not a danger. Nonetheless, the court determines that the other three factors warrant detention under U.S. Code. The court also finds the defendant's proposed bail conditions would not reasonably assure her appearance at future court proceedings. So let's take a look at some of the other allegations here, right? The nature and circumstances of the offenses charged. Well, they're pretty serious. They're saying that she was trafficking underage women for a very long period of time over the course of a number of years with a number of powerful people. Jeffrey Epstein, presumably one of those. Those are serious charges, right? Our society looks at sex violations as catastrophic, right? As in many situations for good reason, because of the nature of the harm, right? If you're having sex with 14-year-old girls who've been sort of conditioned for sex trafficking, there's a good argument that that's the end of the life of that young girl or boy or whatever it is. And so the nature and the circumstances of the offenses charged are very, very high. A converse argument would just say, well, it's just regular sex trafficking. It's something like that. I don't even think you can make a particular good argument. Maybe one argument would be that in other areas, in other parts of the world, the age of consent is lower than it is in the United States. And so, it would excuse some of this behavior, but I'm not sure that they made that argument. We can't tell because we haven't seen any of the underlying documents. All this stuff is kept under seal. So I think the judge is totally right? The nature and the circumstances of the offenses are grave. They're very serious. And the judge is within her purview, within the right to consider that prong to be in favor of retaining her in custody. The weight of the evidence against the defendant. Okay, we don't know much about that yet. We haven't seen the discovery, but the court has. And the court knows, a lot of this stuff is kept under seal. So presumably the judge knows, is the government going to win on this thing or not? And the prosecutors know, and the U.S. attorneys have been making their claims as well. So we'll see what, we'll see what that evidence actually looks like. But the judge, I think, would have the wherewithal to make that determination on their own based on what they have seen in front of the court. What they see in front of the court is different than what we see as the public. We also look at the history and the characteristics of the defendant, and we've seen that, right? She was somebody who was sort of escaping culpability and liability for some period of time. They actually found her at some residence sort of in the middle of the woods, kind of away from anybody because she was on the run, right? She was bouncing around from property to property. They were really trying to track her down due to her connection with Jeffrey Epstein. So, the likelihood here, or I would say the pattern here shows that Ghislaine is somebody who is going to flee, right? She did not avail herself of law enforcement when she was out of custody previously, before she got arrested. She was just sort of on the run, not communicating with them at all. And the idea here that she was just, on vacation, just moving around the country because she likes to move is, I think, a non-starter, right? It's pretty obvious that she was trying to avoid being captured until she was captured. Then they're also talking about the nature and the seriousness of the danger that the defendant's release would pose. And so that's the final prong that the judge says, well, we actually don't really think she's a danger. And I don't know how much I agree with that, right? If she is released and she's somebody who operates within the confines of the law, right? Follows her release conditions, maybe she is a good sport during the pendency of her case and she doesn't do anything wrong. But if she does leave, I think she's probably a pretty big danger, right? She's somebody who is in control of a lot of money. She's in control of a lot of power. She probably has, the allegation here as it relates to Jeffrey Epstein, that a lot of his power came from blackmail material, that he was filming politicians, royalty from the UK, having sex with underage girls and using that as blackmail to gain leverage and to gain power. So if Ghislaine Maxwell also has access to that material, she's a pretty big danger to those people, right? She can really ruffle a lot of feathers, as it were. And so, the judge, I think, was being generous, being favorable, but ultimately did the right thing. I would have been very disappointed to have seen her leave custody. And I say that as a defense attorney because I think she's part of a bigger investigation. In my mind, when we're talking about watching the watchers, Jeffrey Epstein, Ghislaine Maxwell, they have a lot of information on a lot of people in power, and we're all curious as to what that is. And if they could be the tip of the iceberg on this thing and cracking, a little bit more into what they know and what they've been a part of, we may unveil this whole onion with multiple layers of malfeasance that just ripples through the entire power structure of the world, right? It could be that significant. It could be nothing. It could be everything. And so the idea that she was going to get out of custody didn't sit well with me. The judge's order says, as a result, the court concludes the government has met its burden of persuasion that the defendant poses a flight risk and that pretrial detention continues to be warranted. Now, on or before December 30th, so that is literally tomorrow, the parties are ordered to submit a joint letter indicating whether they propose any redactions and the justification for any such proposal. This is signed by Alison J. Nathan, a U.S. District Judge. And so good on that judge. Good job, Alison Nathan, U.S. District Judge. Well done on that for I think making the right move. I think it's in the interest of the country to figure out what actually happened with this case. Jeffrey Epstein is already allegedly gone with the wind, and this is the only key witness. We'll see what happens with her. So that order should come out tomorrow. The full unredacted order, we'll have it for the program. We'll clip out any of the interesting tidbits. So we want to make sure that you join us for that. So hit that subscribe button if you have not done so already. All right, so let's change gears. Let's talk about Congress. Been very critical of Congress this past week or so, and for good reason, I think. Largely, they don't really do anything other than just sign 5,500 page bills worth $2.4 trillion in spending. They do it in about 2.5 hours. They cram it through without even having read it or without even getting comments from their constituents back in their districts. And so we've been a little bit, concerned about that and wondering what is going to happen with this. To catch you back up to speed, last week, both bills were passed. We had a defense authorization bill. We had a COVID-19 relief bill that was tied in with an omnibus spending bill, talking about something like almost $3 trillion combined. So I think 2.4 between the COVID and the omnibus bill, and then another $900 billion over at the Defense Authorization Act bill. And so both houses had passed both of them. Last week, Donald Trump vetoed the defense bill, and he said, nope, not going to sign that one unless you go back and you address Section 230. So we're going to talk a little bit about that because Mitch McConnell is going to be dealing with that issue in the U.S. Senate. The other issue that we were talking about was those massive spending bills, the $2.4 trillion that even Alexandria Ocasio-Cortez said that she had 2.5 hours to read it before they were basically mandated to sign this stuff. And all of the good little sheep in Congress, they did that. They just signed whatever their party leaders told them to do. And that landed on Donald Trump's desk. As we were doing a broadcast, I think it was last week, Donald Trump released a new pre-recorded statement and said, listen, that COVID relief bill that promises $600 in new spending or let's say relief payments to Americans is not enough. He wanted to bump that thing up to $2,000, and it really put the Republicans in a little bit of a difficult spot because now they're sort of, if they oppose Donald Trump, then they look weak to Donald Trump fans in the GOP. And if they go against Donald Trump, then they're going to get primaried. Or if they go in favor of Donald Trump, then they're just Trump sycophants. If they oppose Donald Trump, then they're going to get primaried, and the Trump heavy GOP in these senators' jurisdictions may punish them during primaries on the next election season. So kind of a mess. And well, we're sorting through it. Congress is trying to sort through it. So let's start with the COVID-19 release checks. This is from C-SPAN last night. Looks like this one passed by a very, very large margin. So this was increasing COVID-19 relief checks to $2,000. And this was passed by the Democrats by 231 to 2. And it was opposed by Republicans by 44 to 130, but it still passed the House. So by 275 to 134. So I think they're calling that the Cash Act. It's the cash bill. It's saying that essentially this amendment, it's an amendment to the original underlying bill. So let's back up a little bit. This bill, the COVID bill and the omnibus bill, passed already both the House of Representatives and the Senate. landed on Donald Trump's desk. He signed it into law. Now, he signed it saying that, and this was the $600 bill. This was the original bill, the one that he sort of, threw a temper tantrum over on his pre-recorded statement and then suddenly signed it anyways, right? He was very upset about it. It was a long video. And then a couple days later, he just signed it anyways. And in signing it, he sort of reached into this really obscure statute called the Impoundment Act. We read that statute yesterday where he was saying that, well, what I'm going to do, I'm going to sign this sucker, but I'm going to send the red lines back over to Congress. And I'm going to say, all of that pork spending, all of that money that was being sent overseas to $700 million to the Sudan, another, millions and millions of dollars to Cambodia and Venezuela and Israel and all these different places. Many people are wondering, where's that? Wait, what? Why are we sending all this money overseas out of the U.S. when we have millions of people here who are out of work? They're on lockdown. They are in dire straits financially. What's that all about? So Donald Trump said, well, I don't want the $600 in there. I want $2,000. And so I'm going to sign this bill, but I'm going to send it back down to Congress. And I'm basically going to take a red line and X out all of that pork spending. I'm just going to get rid of it and say, you guys can't do this. And that's going to solve the problem, right? Congress is going to just take those red lines and say, okay, yeah, thanks, Mr. President. We'll get rid of that stuff right away for you. Well, we went through the rules yesterday. We looked at the rescission statute. Congress doesn't have to do anything. They don't have to do anything about that. So it's very nice that Donald Trump did that. It's good that him and his team have identified all of the pork in there, but Congress isn't going to do anything about it, right? And we saw that yesterday with a Democrat. I forget her name. She's the chairperson of the Appropriations Committee in the House. She is indicating that we're not going to rescind anything. Okay, we passed the bill we're happy with. President's great. And if Congress doesn't do anything within a 45-day window, well, then the law that the president signed just goes right into effect. So it's nice that he identified the pork and sent it back to Congress, but doesn't require that they do anything. They can just sit on it. In 45 days, it becomes law anyway. I think they have 45 days to amend the bill or to comply with the rescissions. If they choose not to do that, then it's just law because he just signed it, right? So that's all underway. This is a new bill that they're saying, okay, so now that $600 is in effect, the House wanted to bump that number up to $2,000. So that's where this one came in. So 231 Democrats to 2, Republicans 44 to 130, Independents both were nays. So the total final vote was 275 to 134, according to C-SPAN. So the House now, the House of Representatives, has approved this Cash Act, which is going to increase the $600 to $2,000. And there's some other provisions in there. There's a whole bill about it, but it's basically an amendment to the one that is already in the law. Well, so now once the House passes it, it gets transmitted over to the Senate. And if the Senate moves forward and they also agree to that bill, then it's going to land on Trump's desk. He's already indicated that he's going to sign something like that. And so everybody was watching to say, what is Mitch McConnell going to do? Well, we learned today that Mitch McConnell blocks the unanimous consent request to increase the stimulus checks to $2,000. So you can see here from this article, this comes from the Epoch Times, is written by Zachary Steiber today on December 29th, updated today as well. It says Senate Majority Leader Mitch McConnell from Kentucky on Tuesday blocked the bill that would increase stimulus checks from $600 to $2,000. I object, Mitch McConnell is quoted as saying on the Senate floor in Washington. He blocked a request for unanimous consent for the Cash Act from the Senate Minority Leader Chuck Schumer. Unanimous consent enables a bill to pass without a recorded vote, but the procedure opens up legislation for an objection by a single senator. So now, as soon as this happened, as soon as Donald Trump said, I want $2,000, I want increased payments to Americans who need it, the Democrats were just salivating. They were chomping. They were just hungry. They could see an opportunity here. They saw a major opening and they're trying to drive their truck through it. And they think they're doing a pretty effective job of that. They said immediately, yeah, 2,000. Yeah, that's what we wanted originally. We've been saying that for a long time. The Republicans are the ones who hate middle America. They hate the little guy. They hate the small business owners and so on. They don't want to give you any money. It's the Democrats who want to do that. So look how great we are, right? And now they're trying to get this through in the Senate, so they're just ready to go. Already passed in the House. Chuck Schumer, who's a Democrat from New York, also very, very interested in seeing this happen as well. But Mitch McConnell took a single vote and said, I object, so that is tabled. Remember, he's the Senate Majority Leader. He has a lot of decision-making power about what bills get to hit the floor anyways. He controls kind of a lot of the schedule there. So this article goes on. It says, before objection, objecting, McConnell had briefly touched on the push to increase stimulus checks, noting that President Trump, when signing the government funding package and the COVID-19 package on Sunday, he asked Congress for, quote, more money going to the American people in the form of $2,000 checks per adult and $6,000 per child. The Senate will quote, and this is what Mitch McConnell said, begin a process to bring the issue, one of the three that Trump, quote, has linked together, into focus. Trump had stalled on signing the bills as a way to leverage Congress into approving more $2,000 direct payments. The Cash Act was introduced in the House. It would amend the relief package if it passes the Senate and it's signed by Trump. The House yesterday passed that bill, 275 to 134. I think those numbers are a little bit different, but that was the final vote. Schumer said all 48 Democrats support the bill. That means at least 12 GOP senators would need to approve it, and if it's brought to a vote. And so far it sounds like a number of them are interested in doing that. Marco Rubio from Florida, David Perdue from Georgia, Kelly Loeffler also from Georgia. We've got Lindsey Graham from South Carolina, Josh Hawley have all said that they support the act. So they're interested, meaning when I say support, it means they want more money. They want more the $2,000 payments to go to Americans. McConnell controls which bills are brought to the floor apart from those that are put forward with unanimous consent. He said that he would bring, so that was the COVID-19 and the stimulus bill. So it's looking like that $2,000 payment is dead right now, right? There's nothing else to do with it. Mitch McConnell just killed it, said, I object to it. But then he sort of turned around and said, well, we're going to investigate more of this. We're going to look into some of this. We're going to, quote, begin a process, whatever that looks like, in the coming weeks and days. And so I'm not, I don't know how hopeful I would be if you're expecting that $2,000 check, because a lot of the Republicans are very, very opposed to this. Many of them, I think with some good reason, are opposing a $2,000 check, right? And you may say, well, wait a minute, Rob, you've already been saying that they should, the government has been taking our money for a long period of time in the form of taxation. Now that Americans need it when they're in a time of need, the government should be very forthcoming with returning the people's money back to the people, right? Kind of makes sense to me. And so last week when we were being very critical of this bill, a big part of my criticism was rooted in the fact that this was a massive spending bill for other things that I didn't think were particularly pertinent to COVID-19 relief. We saw all sorts of disgusting, ridiculous pork in the bill. We went through a lot of it here, not only in terms of the foreign aid, but we were talking about burros and horses and all sorts of weird, random stuff that is just sort of in the budget every year that I think is probably unnecessary. Largely a lot of it. It's all pork for the different politicians. They all take it back to their districts and they champion themselves as heroes of their state. But it doesn't really serve any people, in my mind, other than the politicians and their little constituencies there, right? They funnel the money to where they want it to go. And in my mind, that's not a good way to run a country or a business or anything like that. You want to give the people more of their own money. Right? The federal government prints money and then it takes money from us. And so now that many of us need it, I think it's perfectly pertinent for the federal government to focus on giving people more of their money back. I'd be okay with, even just waiving taxes for a long period of time or whatever it is, some sort of creative solution that gives people more money. Now, when you also are just printing money and you're also not cutting any spending out of the bill, meaning, this 2.4 trillion is going to turn into 3.6 trillion or whatever the number is with an increased payments to the American people. That's concerning, right? Now we're talking about spending money that we don't have, and we're going to have to tax more people, either tax more people or print more money, both of which are bad options. So if we're going to do that, now suddenly that $2,000 looks a lot less palatable. Because it's not coming from anywhere. If they were going to take the 2.4 trillion, or if they're going to take, the 900 billion or whatever it is that was going overseas and say, we're going to cut that out, we're going to redirect those payments to $2,000 a month or $2,000 one time or $600 a month or whatever it is for the American people who actually need it, that's a lot more palatable. But that's not what we've got. Right now, we've got the Republicans who are saying, okay, $600 is enough already. We saw an argument from Rand Paul and some of the other more fiscal conservatives saying this is ridiculous. This is socialism. People don't need it, which I think is a little bit calloused on the one hand. On the other side, you've got the Democrats who are just saying, spend whatever you want. $2,000 a month is fine. Yeah, no problem at all. We'll just keep spend. Because if the Republicans oppose it, then it's a political win for them. The Republicans look like they don't care about families. They don't care about grandma who's starving and is going to get thrown out of her apartment. So they both got, sort of their arguments to make, and I don't think either one of them are particularly good. It's looking like, American families are probably not going to get the relief they need. We're also going to be spending an inordinate amount of money that goes who knows where. So that's only for the COVID and the omnibus bill. Now let's talk about the defense bill. McConnell also said that he would bring the defense bill veto for a vote this week. Trump vetoed the package, but was overridden by the House. The Senate appears poised to override the veto as well. Bernie Sanders objected to the push to override as a way to get McConnell to bring the stimulus check proposal to a vote. The House did the right thing. I congratulate them. Now it is time for the Senate to step up to the plate and do what working families of this country overwhelmingly want us to do. Sanders asked McConnell to bring the Cash Act to a vote immediately after the veto override vote, but McConnell blocked the proposal. So, a lot of back and forth on this issue as well, whether or not the Senate is going to override the veto. I think that they will, right? Donald Trump took a stand on this one, rightfully so. I wish he would have taken a bigger stand on the other omnibus bill, but didn't do that. And what's, I think, going to happen is the House already overrode the veto. So the defense appropriations bill, that's going to probably pass, because yesterday we saw they had enough to overturn the veto. So yesterday the votes for the Democrats, 196 to 10. Republicans also joined in, 109 to 66. So that leaves us with a 306 to 77 vote. And remember, in order to override a presidential veto, you got to have 2/3 of the chamber. In this case, 306 to 77. That does it. They only needed about 289, 290 votes in order to get to 2/3 of the 435 members who are in the House of Representatives. So that passed the House. The next question is going to be, what is the Senate going to do? Are they going to get 2/3 of the Senate to override Trump's veto? Probably. So don't expect anything to happen on Section 230 in that. Probably going to be just business as usual, unfortunately. All right, let's wrap up with this last case. This comes from the Second Circuit Court of Appeals. This involves Governor Andrew Cuomo out of New York. Let's sort of frame this out a little bit. So as we all know, we've been living in COVID century, COVID mania. It's been, a lot of COVID going on, about 9 months now. And some time ago in New York, which is sort of, I think, the hardest hit place in the country, California may be rivaling them right now, they issued some pretty severe orders. Governor Andrew Cuomo specifically said, listen, if you are a person of faith and you want to go worship, that's a problem for us here. We're going to really need to impose some pretty hard restrictions on how you go about doing that. We're not going to apply those same restrictions to other businesses, only to you people, because the Orthodox Jews in New York, apparently, they like to worship. They get together. They have a lot of people who congregate, something like 700 people, 1,000 people. They get their worship on and they do it hard, right? And they didn't like that so much out of New York. And so this order was challenged. The order largely was just saying you can't have certain, what they were doing is they were separating the city into different zones, like an orange zone, a red zone. And they would say, if you're in the red zone, you can only have an X% amount of capacity. So something small, like 25% would be for the orange, but maybe 13% would be for the red. And I don't remember the percentages off the top of my head. It's not really important. That's just the structure. And incidentally, a lot of these places of worship were within some of the red zones, right? And they were in these areas where it looked like they were just being totally singled out by the federal government, or I'm sorry, by the state government here. This is the state of New York. And so what they did is they sued. We have Agudath Israel of America suing Andrew Cuomo, and we also have the Catholic Diocese also suing Andrew Cuomo. Two kind of separate cases challenging the same order. And they were successful. The pretty interesting case here out of the Second Circuit. The way that this worked is they filed the original lawsuit in a lower level district court. That district court sort of denied their request. They said the governor has a lot of power. COVID is an emergency. They can do whatever they want. The executive branch has just gobbled up power all over the country. And the courts have been largely deferential until now. We're seeing some interesting things, I think, out of the Third Circuit. We see another one here out of the Second Circuit where the courts have just said, all right, enough already. All right, you get your COVID excuse. You can do whatever you want under COVID for a certain period of time, but eventually enough already. You're trampling all over people's constitutional rights. We're not going to let that stand. And so this has kind of worked its way through a number of different chains. It started at a lower level district court. I think it went up to the Court of Appeals. Then they also ruled against the religious groups. Then they took an appeal directly to the Supreme Court, and they sent that back down and said, listen, here's how we're going to handle these cases. You're going to apply strict scrutiny, which we're going to get into here. But now that the Supreme Court has sort of hinted that this is how we're going to be interpreting these things, it trickled back down to the Second Circuit, and we now have this ruling. So let's take a look. All right, this is from the United States Court of Appeals for the Second Circuit. The August term, it was decided yesterday on December 22nd. Oral arguments took place 10 days earlier on the 18th. And you can see here, this is the parties who are suing each other. So this is Agudath Israel of America, of Kew Garden Hills. We've got Madison. We have Rabbi Yisroel Reisman, Rabbi, and so on, right? I can't pronounce these names, but they're all suing Andrew Cuomo. And then the second part of the header of the lawsuit is also the Roman Catholic Diocese of Brooklyn, New York, is also suing Andrew Cuomo. So two different religious organizations from two different religions are both suing the governor. They're saying this executive order is unconstitutional. The opening of the complaint here is as follows. It says, on October 6, 2020, in response to an increase in COVID-19 cases, the Governor Cuomo issued Executive Order 202.68, here known as the order, which, among other things, limits the maximum allowable occupancy in, quote, houses of worship. And it's important to understand that quote there. Okay, they're saying that this, when they're quoting things like that, they're saying this is in the order. Right, so they're specifically calling out houses of worship. They're saying they're maximum allowable occupancy in, quote, houses of worship in certain zones to 10 or 25 people. The appellants, the Roman Catholic Church and the Israels of America, they say they seek to enjoin the governor from enforcing those 10 and 25 person capacity limits. They argue this order violates the free exercise clause of the First Amendment. The United States District Court for the Eastern District of New York denied their motions for a preliminary injunction. Okay, so they're saying, listen, under the First Amendment, we have a right to freedom of religion. We can practice however we want, free exercise. There's a lot of case law about this. It's been argued a lot. The only real rub in this is COVID. Okay, COVID's kind of a new thing, and everybody's figuring out how to respond to it and what different standards should we apply to it. So I want to give you a little bit of a crash course on constitutional law, talk about the different levels of scrutiny that exist. So let's frame this out a little bit. If the government does something that tramples on your constitutional rights, let's say, for example, freedom of speech, right? You want to go out and say something. Well, if the government is going to pass a law that prevents you specifically from doing that thing, from going out and speaking freely, that sounds like the government is encroaching on your First Amendment rights, right? It's pretty obvious. And so how would we analyze that government law? Is there a framework that we would say, okay, well, that law is specific to me individually and freedom of speech, and it's trying to govern the content of my language, so we're going to apply that standard. But what about this other law that is sort of just general? It just says, listen, you can't be out on the streets at 2 a.m. with a bullhorn shouting, death to America, right? You can't do that. That would be an unlawful thing to do. And if the government wanted to pass a law that says no bullhorns shouting, death to America at 2 a.m. on the streets, well, you could have some good arguments. Well, you could say, well, they're saying you can't say death to America. That's sort of limiting the content of the speech. It sounds like you're trying to censor them. So maybe that portion of the law would get thrown out. But the other portion of it, saying you can't use a bullhorn at 2 a.m. in the middle of a busy city street, is probably going to be okay, right? Because it's a sort of a neutral law. It's generally applied. The government has a rational basis for passing that law, and it's not really prohibiting your freedom of speech. It's more like a time, place, and manner restriction that says, no, you have plenty of free speech. You just can't do it at 2 a.m. Come back tomorrow, 8 a.m., bullhorn it up, have fun, right? And so that's the type of framework that we're looking to decide what laws stay, what laws go. If the government is going to pass a law on abortion, or if they're going to pass a law that adversely implicates a certain demographic, how do we judge those laws? It's very, very complicated. A lot of time spent in constitutional law talking about these issues. Most essays on bar exams and law school essays involve some sort of First Amendment analysis. And so let's take a look at this one. The governor's executive order was put into place, and now we're trying to decide, and this is what the courts have been dealing with, is what standard? How do we judge these things? So I found an interesting chart over on Google Images. I did not create this one, but I did find it, and I thought it was somewhat interesting. It's condensing like thousands of pages of constitutional law onto one chart. But let's run through it a little bit here. So this is where we're talking about the different levels of scrutiny. So once again, if the government is passing a law, how do we judge it? So one of the first questions we have to ask ourselves is, what standard are we under? And there are three different standards that we study in constitutional law. One is what's called a rational basis test. The other one is called intermediate scrutiny, and the other is called strict scrutiny. Okay, strict scrutiny is obviously the most strict. And what we're talking about here is the means. What is the law? What is the law attempting to do? Right? There's a harm. The law comes into play. It's attempting to resolve a problem, to create a solution. And so under the rational basis test, it's very, very loose. It's a very low standard. It's basically saying that if the law was rationally related, meaning it's just rational. Okay, we're going to pass a law that says you can't use bullhorns at 2 a.m. It's rationally related to peace and quiet at 2 a.m. in the middle of a busy street. If the prohibition there that you can't use a bullhorn is rationally related to the government wanting to keep the peace and quiet, then that's good. It meets that prong. Does the government have a legitimate basis in keeping you from using a bullhorn at 2 a.m.? Yeah, they do, right? It's pretty legitimate. I think most Americans would agree. Yeah, we want the government to do those types of things. Most of us, or some of us do. Is it the least restrictive means of preventing noise? It doesn't really matter here. We're not asking that question because the government has a lot of leeway. When we're talking about a rational basis test, the government has they can basically do whatever they want. If it's any conceivable purpose, if there's any justification for the law and the government is doing something that is within the purview of the government, in this case, it would be keeping the peace and quiet, that's it. It's just the rational basis test. And so that law would stand. Now, when we start talking about more complicated issues, more constitutional issues, like in this case, practicing your religion, we have to start analyzing this at a higher standard because now we're talking about a very, very fundamental thing, which is practicing religion or freedom of speech. And we jump down from a rational basis standard to something much higher. So we have another sort of intermediate tier, which we don't spend a lot of time on. But what the court is now saying is that they're going to be applying, at least in this case, in this circuit, strict scrutiny to the government law. So now they're asking the question. Think about this once again in the context of the Governor Cuomo's executive order. Was it necessary in order to achieve the government's interest? And if it was the government's interest compelling? Was it an actual? Was it the purpose of the law? So do they have is it necessary to achieve that government interest? And if it is, then is what the government is proposing to do, is it the least restrictive mechanism possible in order to achieve the government's goals? The government has to show that it is. In other words, there's nothing else we can do. This is absolutely necessary. We're going to be encroaching on your freedom to practice religion because there's literally nothing else we can do. This is it. And this is absolutely essential to us meeting our goals. In this case, preventing the spread of COVID-19. So they need to show that it's necessary to prevent the spread of COVID-19. And they also need to show that there's nothing else that they could have done that would have prevented the spread of COVID-19. They had to eliminate your ability to congregate in your religious places of worship, which is a bit of a stretch, as we're going to see here. So the order goes on. It says, before issuing the order, so let's talk about the underlying executive order before we get there. So Andrew Cuomo passed this executive order. It went into effect. Before doing so, the governor made public statements indicating that the restrictions were motivated in part by concerns about religious gatherings. So this is from the court's order. This is literally from the Second Circuit. It says the governor was motivated in part by concerns about religious gatherings, not just gatherings, religious gatherings. For example, he noted the source of the first coronavirus hotspot in New York, quote, was an Orthodox Jewish man who went to a temple, end quote, and observed that, quote, Orthodox Jewish gatherings often are very, very large, and we've seen what one person can do in a group, end quote. The governor then said he would be meeting with members of the, quote, ultra-Orthodox Jewish community, end quote, and if they would, quote, not agree to enforce the rules, then we'll close the institutions down, end quote. One day later, he issued the order. Okay, so, did he meet with them? I don't know. If he did, was it a serious meeting where they're talking about these issues? I don't know, right? But he's specifically, in quotes, addressing a particular religious community and saying, we'll close the institutions down. Jewish gatherings are very, very large. We've seen what one person can do. He says it's an Orthodox Jewish man who went to a temple. So he's pointed right at the Orthodox Jews. He's sort of singling them out and says, we're going to close the institutions down. One day later, he did. The order was not accompanied. So this is, once again, Governor Cuomo's order that went into effect. It was not accompanied by any contemporaneous explanation of its specific limits on houses of worship. In this litigation, the governor offered declarations, just like we saw a lot in the election lawsuits. The governor's using declarations, but when you use them in election lawsuits, apparently they have no meaning. Here, they were relying on some of them. One from a guy named Dr. Howard Zucker, Dr. Blog, Dr. So-and-so, all these individuals. The declarations explain that, quote, large gatherings present the greatest risk for rapid and widespread transmission of the virus in a community, citing reports of, quote, super spreader events at a church in Arkansas, a wedding in Maine, a religious service in India, and a choir practice in Washington. Comparing religious gatherings to restaurants, the declarations also asserted that the idea of a religious service is a group of people coming together as a community to interact and pray together, that generally the congregants arriving and leaving at the same time are together over an extended period of time, and that this type of close interaction, while having a deep meaning for the congregants, poses a higher risk of transmission of the virus, right? And the declarations, let's see, the declarations did not purport to assess the transmission risk of religious worship based on any data, much less to compare religious worship with essential activities, and they did not explain how the governor arrived at the specific numerical and percentage capacity limitations in the order. All right, so what does that all mean? Well, the governor is now filing a bunch of affidavits, or declarations in this case, from other doctors. We have a director of Department of Health, Division of Epidemiology. We have a commissioner of the State Department of Health, Dr. Zucker, and so on. And they're all saying, listen, if you have big groups of people congregating and worshiping, it's sort of the same thing that we've seen elsewhere in the world. We've seen a church in Arkansas had problems with this, not in New York, but out in Arkansas. Also, there's a wedding in Maine. Weddings can be religious, that's close enough. We have a religious service in India, okay, which is on the other side of the world. And we have a choir practice in Washington. And, and churches have choirs. And they're saying that in all of these different areas, there were some bad effects of that. And so they're going to sort of analogize from those other incidents into what should be done in New York. And when you think about it, right, you can make some pretty good arguments for it. I'm a Catholic boy. I grew up Catholic. I went to a Jesuit high school here in Arizona, and I know what Catholic church is. I've never been to a Jewish church. I've never been to an Orthodox Jewish church. That's not true. I've been to bat mitzvahs and bar mitzvahs and things like that. But generally, I don't know how they congregate as well as I do the Catholics. And the Catholics here are also suing. So I can tell you that in a Catholic church, there is a lot of that. There's a lot of conversing, right? There's a lot of singing. We stand and sit and sing and stand and sit and sing, and then we take communion, right? And when you're singing, first of all, you're sort of, ejecting air out of your mouth, singing for Jesus. And certainly you can see how that can spread a virus in the atmosphere around to other congregants. We also do communion, right? When we get up, we go in front of the priest and we take a wafer with the body of Christ, the blood of Christ, right? In some circles, that's a hand thing. You get it, you form a line, you get in front of the priest, you take your host, you consume it, say your prayer, you move on to the next thing. In some other Catholic churches, you're actually sipping from the same wine glass. Okay, that's a pretty big COVID problem, literally. I mean, what you do is you walk up and the priest will, or whoever's a part of the congregation who's performing the service, will hand you the cup of wine, you'll take a sip, they wipe it off, they spin the cup around, they give it to the next person, they do that for 100 people, right? So everybody's drinking from the same cup. And so, yeah, those types of things are certainly concerning in the age of COVID. We hold hands, we sing the Our Father, we shake hands, we give hugs for the sign of peace. There's a lot of that stuff going on. So you can understand that argument. You can understand them saying, well, listen, there's a lot of interpersonal activity going on in these places of worship, and so therefore we got to do something about it. But what they're missing here is some of the mitigation. Okay, all that stuff is nice to do, but you don't have to do that, right? You don't have to share a wine glass. You don't have to hold hands. You don't have to, give hugs when you're offering peace. You don't even have to, be close together when you sing. You can do social distancing. There's a lot of things that you can do to mitigate the effects of that. And saying that you just can't practice your religion because of some of these incidental, what I would call marginal concerns are possible, doesn't mean that you get to just say, all right, well, that's it. No more religion. No more God. No more prayer. No more congregation. You guys are on your own. That's where I think this crossed the line, as we see here. The declarations did not purport to assess the transmission risk of religious worship based on any data, much less to compare religious worship with essential activities, which are, of course, a lot of those are non-religious. They did not explain how the governor arrived at the specific numerical and percentage capacity limitations in the order. So they just picked 25 people. They just picked 10 people, and they said, that's it. That's all you got. Well, what if we were socially distanced? What if we were following all the CDC recommendations? What if everybody was singing with their masks on and we had individual wine, and we had individual hosts, and we were following all of the protocols at every step of the way? We still have to be 10? We still have to be 25? That seems kind of arbitrary to me. It doesn't seem narrowly tailored to achieving the government's goal. It doesn't seem like it meets that level of strict scrutiny. There are other things that you could do to meet the same goals of not spreading COVID without eliminating the entire service. This is where the court is having some issues. So this order goes on. It says the free exercise clause protects both an individual's private right to religious belief and, quote, the performance of or abstention from physical acts that constitute the free exercise of religion, including, quote, assembling with others for a worship service. That's all protected. Okay, that was decided by the Second Circuit in 2014, and they're citing another case from 1990. This protection does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability. So again, this is where we're going back to that idea of having a bullhorn at 2 a.m. in the middle of the street. Okay, if you pass a law prohibiting bullhorns at 2 a.m. in the middle of the street, that's a neutral law. It's not going after what you're saying. It's not going after you personally. They're not saying that Orthodox Jews can't use a bullhorn at 2 a.m. They're just saying nobody can, right? It's a neutral law of general applicability. That type of stuff is fine. But here, this is not neutral. Official action that, quote, burdens religious conduct that is not both neutral and generally applicable is subject to strict scrutiny. And to determine neutrality, this order goes on. It says we begin with the order's text. In the text, they have to analyze whether this was discriminatory or not. And I'm talking about the text of the order. The text, the reason why we want to look at the text, the literal language, is for the minimum requirement of neutrality is that a government policy not discriminates on its face. So if the text of the order is discriminatory, that's kind of it. That's all we need to know. The order in this case fails the basic standard by explicitly imposing on, quote, houses of worship, end quote, restrictions inapplicable to secular activities. And the order says here, in quote, in a red zone, while a synagogue or church may not admit more than 10 person, businesses categorized as, quote, essential may admit as many people as they wish, end quote. That's from the order, subject to only the less stringent 50% capacity limit that's applicable to all businesses. So literally in the order itself, it says in a red zone, while a synagogue or church may not admit more than 10, businesses may admit as many people as they want. So if you have a Walmart, if you have a grocery store, everybody can come in. But if you are a religious organization, you're limited to 10, and you're specifically called out in the language of the law as a house of worship. So you can't do that. It says rational basis review applies when neutral and generally applicable policy incidentally burdens a religion. A policy that expressly singles out a religion for less favored treatment, as here, is subject to strict scrutiny. And the fact that this case arises from a global pandemic is most relevant is at the first prong of strict scrutiny. That is, it says, quote, stemming the spread of COVID-19 is unquestionably a compelling interest. Right? We all agree with that the government has a strong interest in stopping the transmission of COVID. We all want the transmission of COVID to stop. I don't think anybody is in favor of COVID. Our focus then turns to whether the restrictions here at issue are narrowly tailored and use the least restrictive means available to achieve that interest. To be sure, the uncertainties that accompany many novel emergencies may make it difficult to assess whether, for example, a less restrictive alternative actually exists, calling for a measure of humility on the part of the reviewing judge. But we grant no special deference to the executive when the exercise of emergency powers infringes on constitutional rights. Yes, that is precisely what the three-tiered framework for analyzing constitutional violations is for, and courts may not defer to the governor simply because he is addressing a matter involving science or public health. Even in a pandemic, the Constitution cannot be put away and forgotten. And they're citing there, I think that was a dissent from Governor Gorsuch or some opinion from Governor Justice Gorsuch on the Supreme Court. So even in a pandemic, folks, the Constitution cannot be put away and forgotten. Quoted in the Second Circuit as it relates to COVID lockdown. So can we please see more of this? I know many of us have been disappointed with the judiciary for some time these past few weeks, but more of this is okay with me. All right, and our last story of the day, we got some bad popo here in Arizona, right in our backyard. Some bad hombres out there. We have a new report that a Phoenix police officer said, quote, if the mayor defunds the police, I'm going to shoot her, end quote. That's from a police officer here in Arizona. Said it to other police officers here in Arizona. This article comes from AZ Central, written by Uriel Garcia and Jen Fifield over on Twitter. If you want to follow them, both good follows. Says here, on the afternoon of October 21st, 7 Phoenix police officers were gathered for a briefing in Cave Creek, which is a little kind of small town up north of Phoenix. It says that when the meeting diverged into a discussion about the defund the police movement, Officer Stephen Poulos expressed his thoughts. The room went quiet because he said, quote, if the mayor defunds the police, I'm going to shoot her, end quote. Poulos, his sergeant recalled hearing the officer say, referring to Mayor Kate Gallego, who you can see here on the screen. The sergeant responded to Stephen Poulos and said, you're not going to shoot the mayor. Poulos doubled down and said, quote, that's a promise, he responded. So, okay, so that's one interpretation to, I guess, the defund the police movement. Poulos' comments were detailed in a Tempe police report recently released to the Arizona Republic as part of a public records request. I haven't gotten a copy of that yet, but I'll be very interested to get it. A Tempe police detective interviewed the sergeant and 5 other officers who were at the meeting with Poulos. So listen to how fun this is, okay? 7 cops are at a hearing, and one cop says one thing to another sergeant in front of the room. Okay. If she moves to defund the police, I'm going to shoot her. You're not going to shoot the mayor. I'm going to do it. He doubles down. So then we have another detective or somebody from the Tempe police, which is another city in Arizona. So we got multiple cities in play. And that investigator goes and talks to a number of the different officers who were in the room when this guy said something. Now you're going to see 3 different versions. I think it's 3 different versions of what these officers heard. Okay, so now we're getting conflicting reports from the different officers. So you can attribute this to a number of different things. 1, the cops are all just trying to cover for themselves. Number 2, the cops just are terrible at remembering things. So either both are not good. 1, they're covering for somebody who said something very stupid and criminal in my mind. So they're covering for him. Or number 2, they can't remember anything. In which case, why are they writing police reports? What are they doing on the force? They can't even recount their version of the events accurately back to another investigator. So it's just a mess here, folks. All right, so here it goes. The comments were detailed in a police report recently released. A Tempe police detective interviewed the sergeant and other 5 officers who were at the meeting with Poulos. Some officers remembered Poulos' threats differently, according to the police report. One officer said he remembered Poulos saying, if they defund us, the first person on my list is the mayor, which is a little bit different, right? He doesn't say I'm going to go shoot the mayor. He says the first person on my list is the mayor. So that officer got it a little bit wrong. A third officer remembered Poulos saying, if they defund the police, I'll go over to the mayor's house and shoot it up. So we got 2 different versions. The third version, of course, is the one that was reported. So 3 different interpretations of what actually happened there. Number 1, he said, I'm going to go over there and shoot the mayor. He said, you're not going to shoot the mayor. Then he said, oh yeah, I am. I'm going to shoot the mayor. Somebody else says, well, the first person on my list is the mayor. Third person says, I'll just go over to the house and shoot up the house. So 3 different versions, 3 different cops. They were all in the same room and they can't get their story straight. So the next time you read a police report and you look at it and you say, well, that cop was there. He saw what happened, right? Take it with a grain of salt. We have 3 different people who are all in the room with 3 different versions of events. by their own police report. 3 of the officers told the Tempe detective they believe Poulos would not act on his threat because he was just venting, according to the police report. He says, it was just a joke. After the meeting, the police report says Poulos backtracked and told the sergeant his comments were a joke, right? He says, quote, I don't know why they make a big deal about it. It was just a joke, he told the sergeant, according to the police report. The comments, whether made in jest or not, were taken serious. The Phoenix Police Department asked Tempe police to criminally investigate the case, which is a good call, right? And calling them to investigate their own guys. Phoenix police also opened an internal affairs investigation to determine if Poulos violated any policies. That report has not been released. A Tempe police detective has forwarded the report to the Maricopa County Attorney's Office, which will decide if it will prosecute Poulos. The case was submitted for review of charges of making a terrorist threat and threatening or intimidating somebody, according to a police report. And that's right. Other people in Arizona have been charged with crimes like this. Other people in Arizona are sitting in custody for crimes like this. Okay, it's happening all over the country. A lot of people aren't talking about it. If you go on Governor Doug Ducey's Twitter account, you're going to see there's a lot of angry people up there every time that he says we're going to lock down again. Oh, not anymore, but months and months ago, he was going through and he would say, well, we're going to lock down for another couple weeks, and people would be just on there blowing him up. And it's not just here, right? People are very angry at our politicians. We saw, I have no love for Governor Whitmer out of Michigan, Big Gretch Rona, but she had 6 individuals who were talking about literally kidnapping her, and they were scoping out her residence in order to do so. People are very angry at the government. You can't make those types of threats, obviously. But this cop, is he going to get away with this stuff? Is he going to get prosecuted to the same extent that you or I would? We're going to see. We don't know yet. Currently, it sounds like he's out of custody. Maricopa County, they're going to determine whether or not to file charges against the guy. We'll see. If he does have charges filed against him, what's the penalty going to be? Okay. Looking forward to following this one along, seeing where it ends up. What does Poulos have to say about any of this stuff? He says he told the Tempe police detective that he would not provide a statement. He got an attorney already, Josephine Hallam, and he declined to comment to the Republic. Both good moves on that. Okay, cops want you to talk to them. As soon as this guy lawyered up, he's not talking to anybody. Good move. Don't talk to the cops. Even if you're a cop, you don't talk to the cops. You understand how that works? Sergeant Mercedes Fortune, a spokeswoman for the Phoenix police, said in an email on Tuesday, Poulos is on administrative leave, probably still getting paid. The administrative investigation is ongoing. Prosecutors are still reviewing the case for any possible charges, said Jennifer Luer, spokeswoman for Maricopa County Attorney's Office. Gallego had not read the police report before the Republic sent it to her office on Monday. Mayor declined to comment on the threat, including whether she wanted the officer to be prosecuted, until she had time to review the report to her communications director, Janine Lecure. So there you have it, folks. We have one cop in Arizona telling other cops that he's going to go shoot the mayor. But maybe that's not the case. Maybe he said something different, because the 3 cops who are all trained to observe and investigate and write down facts without making mistakes, to look at a red car and say it's a red car. It's not a maroon car. It's a red car, right? To be very detailed about what they see and how they report things. They can't even get their story straight. They were all in the room. They all three different people heard 3 different things. This guy's on administrative leave, when I can tell you that there are other people around the country who are not getting those same benefits, right? The cops show up all over the place. They get very, very aggressive with individuals who make these types of threats. But this cop makes those threats. We're going to see if he even gets charged. So we want to make sure that you follow along with us as we follow that story. Another good reminder to subscribe if you have not already done so. And so that is it for the material. Let's dive into the super chats. We have one from Ryan Renard, who says, sorry, this isn't related to tonight's topics of discussion, but do you think Trump has better than a 50-50 chance to turn this election in his favor and serve 4 more years? I'm sorry, Ryan Renard. I don't think it's even close to 50-50. I think sort of at this point in time, much to my dismay, it's not looking good for the president. I don't think that anything really substantial is going to happen on January 6th. My inclination is that senators are not going to join in the objection. Right now, we know that Rep. Mo Brooks has a number of representatives who have decided that they're going to be objecting when the House counts the electoral votes. They need to be joined by senators. I don't think the Senate wants to take it up. I don't think they want to get into it. And here's why. If they do, they're going to have a floor vote. Then they're going to all have to go on record as to whether they support the president or not, whether they believe in voter fraud or not. It's going to require them to take a difficult stand. They don't want to do that. So they're just going to defer. And I think they're going to round up, there's only 100 senators and there's only 52 Republicans. If anybody is thinking about joining in the objection, that one senator joining an objection from the House of Representatives is going to drag the Republicans into a can of worms. And so they're going to do everything they can in their power to make sure that no Republicans join. I think what an interesting tactic would be to have the Democrats join. Have a Democratic senator join one of the Republicans and demand a floor vote, because then it would force the Republicans to make a decision. Where do they stand? Do they believe that there was some electoral fraud, or do they believe not? Do they support the president or not? Right? It would force them into that corner. But if they were forced into that corner, the reason why that would backfire for the Democrats, I think, would be because maybe they do vote. They have the Senate. Maybe they do vote to throw out Pennsylvania's votes. Right? So there are a couple possibilities. I think largely it's probably going to go out without a bang, unfortunately. I think that this election had a lot of problems. I don't think that the Trump team, his legal team, has done a very good job in being persuasive about what those issues have been. I talked about some of this yesterday on Uncivil Law. So you can, actually, this is a great segue. I was going to mention this. I was on Uncivil Law's channel last night. I totally forgot to clip this out for this program, but we talked about this. He kind of asked me that question, and I went into a big explanation about, remedies and harms and sort of, the general malfeasance of the election at large, but not being able to specify it in a compelling manner in a format that a court is going to accept. And so I talked a lot about that on his channel. We had a good conversation. I would encourage you to go check him out. His handle is at Uncivil Law. It's right here on YouTube. He's another lawyer. He talks about a lot of these same issues. Nice guy. Has really kind of encouraged me to go and do some more interviews and be more, I would say, communicative with other attorneys. And so check him out and subscribe to his channel if you're looking for more legal stuff. So I'm sorry, Ryan. I know that is not a popular opinion, but I got to be honest with you. I have to tell you what I think is going to happen. I think at this point in time, it's a long shot. Unless there's some other new information, unless there really is some Kraken out there that drops. Largely, a lot of this stuff has seemed persuasive to some degree, but I think the remedy. The remedy that they're requesting doesn't necessarily match the harm. And so right now there's only kind of one path to a Trump victory, and that's in the House of Representatives. And if the senators are not willing to join the House during the counting of the electoral votes, it's not going to look good. So I know it stings. I know it's not what you want to hear. I know a lot of people, anytime I sort of talk about this stuff, we actually lose subscribers. We've had that happen a couple times, but it's just the reality. It's unfortunate, but I hope this is a little bit of a wake-up call. And just because Trump doesn't win re-election doesn't mean that his sort of, style goes by the wayside. I think largely he's going to be considered to be a martyr, and people are going to be very upset about that, myself included. I was very disappointed with what I saw from the media, from big tech, from our senators, from the so-called Republicans. I think the party without Trump is largely irrelevant. If there's not Donald Trump in the GOP, who's left? Who are people turning to? Josh Hawley? Lindsey Graham? Do we have a particular governor? Maybe Ron DeSantis? It's kind of dead, right? Not much left. And that is going to force a realignment. The party's going to have to get it together. They're going to have to recognize that they're not playing T-ball anymore. Okay, the Democrats are out for blood. They're literally changing the election rules before the election to favor them. And it worked, and they won. And the Republicans were caught flat-footed. So maybe now, when the Republicans are sort of exiled and they're out in the wilderness finding themselves, they'll get more in touch with the things that actually matter to Republicans or to conservatives or to people who are, I would say, more inclined to be connected to concepts of freedom and liberty, less about government, spending, bureaucracy, over-encroachment around the board, high taxes, all of those things. The pendulum is going to swing the other way, and I'm hopeful that the country is better off for it, even though Trump is not in the White House. We got Wolfgang Deo, who says if Trump is an illegitimate president, does that mean he has 2 more terms? Looks like I can agree with a Democrat. So good to see you again, Wolfgang. Yeah, Trump, Trump, I think, is kind of going to be sort of a pseudo president. There's going to be a large part of the country that still thinks he was the president. They're going to be looking to him for insight and guidance. He doesn't have any legal power to do much of anything. But if if he's leaning one way or the other, a big portion of the country is going to swing with him. And that's a powerful thing. We have Gold Chump, who says, I think it is time for Wolfgang Deo to go to $6 per super chat from Gold Chump. We got Wolfgang responding, says, hey, I still have some more money on my credit card. LOL. Looking for a new year and for a better environment. And Wolfgang Deo says, wow. So, and Wolfgang drops in a 666 super chat. So I don't know if that's good karma or not, but thanks, Wolfgang. Thanks, Gold Chump, for hashing it out there in the chat. We have Isaac Castillo, who says Maxwell gets denied bail while a meth user with mental issues gets released next business day after terrorizing neighborhoods while on meth in California. Yeah, so California. I don't want to turn this show into a rip on California, but I mean, they have so many problems going on over there. One of the sheriffs, I think, was not even prosecuting like 7 important crimes. And I'm a criminal defense attorney, right? I in favor of sort of understandable laws that are not overly harsh. I don't want to see people unnecessarily arrested, but the crimes that the sheriff out of, I think the LA Sheriff's Office or whatever, they stopped prosecuting some important ones like resisting arrest and things like that. I mean, bizarre. So I don't really know what they're doing, but it's a good point, Isaac, that there is sort of an imbalance in laws everywhere. We have World War Wit, who says, can't quo warranto be used on the electors from Georgia, Pennsylvania, etc. in question due to procedural misconduct or other irregularities? So I think what you're referring to is the idea that you can go and sort of issue warrants to arrest individuals, sort of like a citizen's arrest analogy, that there are people in there who are working their way up into the levers of government and they're violating the law. And so we're going to use sort of an old, obscure common law concept to go and remove them from power. And I understand the point. I mean, people are really right now sort of looking to different areas of the law and seeing what they can use to craft a good and compelling argument. We're seeing this with the Pence lawsuit, right? They're suing Mike Pence because they want him to be able to decide the president on his own at the time when he's counting the ballots. They're referring back to the 12th Amendment. And so we've seen that. We've seen some of the Impoundment Act from President Trump. We've been seeing a lot of inclination about martial law and sort of, bringing in other areas, I would say, tentacles of the law back into our current system. And I understand why people are doing it. They're looking for some hope, but I just don't, I don't think so. World War Wit, honestly. I mean, I don't see any rational basis for that. I don't think that any court or any part of our existing power structure would entertain that, even though it is an interesting idea. We have Wolfgang Deo, who says 3.14, let us hear your battle cry. Do I have one? Wait, I'll give you my battle cry when I'm ripping on taxes the next time that I do that, because that blood gets boiling when that topic comes up. We have Ma, who says, question, sex with anyone under 18 in the U.S. without Romeo and Juliet exceptions is very illegal. Yes, someone was trying to make an argument in chat that age of consent is all that matters, and I feel that's extremely dangerous disinformation. Yes. So generally, yes. I mean, if we're going to talk about generalities, remember, I'm licensed to practice law in Arizona and California. I can't speak to all of the states anywhere. But yes, an adult having sex with a minor is very frowned upon in the United States. Okay, it's not even something to toy around with at all. If you're even in the realm of possibility that you are an adult having sex with somebody under the age of 18, it's just not worth it. It's just stay away from that, right? Just hard no on that. This is not legal advice, but right, there's too much risk there. There are certain very, very nuanced rules in various states that, like for example, if you are 18, but your girlfriend's 17 and you were both in high school together, for the last year, and then you graduate, but she's still in high school. Well, there's kind of a window there. And so maybe you're in one of those exceptions, right? It's still just not even worth it. Okay. It's such a big problem. And the issue here when it comes to underage, having sex with somebody who's underage, is that this is what's called a strict liability crime. Okay, which means you don't even have to know. Just the fact that you did it is enough. So you see this example come up when somebody's 30, they have sex with a 17-year-old, they thought she was 19. Okay, she lied, she had a fake ID. He didn't know. She was in a bar maybe. Well, she was in a bar. I thought she was 21. She was here. You had sex with her. She's 17. Parents find out. You get prosecuted. Doesn't matter that you didn't know. Doesn't even matter. The law says that the fact that you engaged in that act is enough in most states. I can't speak to every state, so take this with a little bit of. I'm talking in broad generalities here, but yeah, the idea here that you're under the age of. You can have sex with somebody under the age of 18 it's very, very problematic. And in other parts of the world, I know it's not that strict, right? America gets called prude a lot for that reason, saying, well, other countries it's 16 or it's 14 in some countries. I'm not making a judgment call on that one way or the other. I'm just saying it's a very dangerous, very, very dangerous territory. And America largely penalizes those types of offenses very severely. Extremely severely. Prison for a first-time offense. Don't even think twice about it. So be very cautious about that. When I was talking about Ghislaine Maxwell, I wasn't trying to excuse any of the things that she's alleged to have done. I was just trying to sort of steelman an opposing argument to say, like the defense is probably trying to do. She was very removed from this. Jeffrey Epstein was at fault. She had no idea what he was doing to these women and so on. And that's not to negate any of the severity of the underlying allegations. It is a very, very serious offense, and it's a scary thing. I don't have kids, but I would certainly worry about that if I had a boy or a girl, about that type of stuff, because the law, at least in Arizona, is so harsh, and I've seen it really sort of enforced problematically. I've seen people who are in very, very close call situations where it was something that was mostly consensual. Parents knew, everybody was involved. The relationship went sour. Parents now want to use the fact that they were technically in violation of the law to ruin some young guy's life. I've seen that before. I've worked on those cases. It's heartbreaking, because that person is going to be a sex offender. They're going to have to be on probation for essentially the rest of their lives. They're going to see sex counselors because they think that person is a pedophile. Right? Somebody who's 18 and a half having sex with somebody who just turned 17 or was 16 and just turned 17, even though they were, in younger ages together, the parents knew, everybody was, the whole thing was okay. It goes sour. Now, both lives in my mind are ruined. The woman's life is ruined. The guy's life's ruined. The parents' lives are ruined. It's just a mess. So it's just better to just not even play in that playground at all. Thanks for that meaty question there, Ma. Thanks, Ma. We have Wolfgang Deo, who says, how is the people's money, our money, to do as we please? We just expect to be defended by the military without paying for it. Food bank people. So, yeah, I mean, yeah, it is our money, right? It's our military. We pay for it. That's what our taxes go to. The idea that the government is just going to give people $2,000 and that money comes from thin air. The government doesn't make any money. They don't produce anything. They take our money, they buy a bunch of stuff, they produce a bunch of stuff that we are sort of giving them the resources to do stuff with. But thanks, Wolfgang. We have another one from Mike Gayo, who says a devalued currency is easier to pay back debt. Okay, so that's one interpretation of it. Thanks, Mike. We have Jamie Zaluf, who says, please explain why Congress prefers to give money to other countries versus to Americans. Well, I think, Jamie, the answer is because if that money was being circulated in the U.S., it's a lot harder to steal. It's a lot harder to rip off. When you send money to, let's say, the Ukraine, Joe Biden can go and talk to the president and say, listen, we've got $1 billion with your name on it. I know you're prosecuting Burisma. My son is on the board of Burisma. Don't like that. So unless you get rid of the prosecutor who's prosecuting Burisma and thereby my son, you're not going to get $1 billion. And so that enables these kids of politicians to go around the world, their business partners, their brothers, to go around the world and engage in something, right? Business, you can call it business, bribery, corruption, whatever it is. They can engage in that freely. And then the United States politicians can use foreign aid and their influence back here at home to dictate how those countries are going to get money. They have leverage over those countries. So I think that's what it comes down to. They can grift off of those grants to foreign countries, and we can also use it as leverage in order to get what we want. Sometimes it's probably done with America's best interest in mind. Sometimes it's done in the event where Joe Biden says, stop prosecuting my son. Neither is particularly good in my mind, though. We have Elaine Smith, who says, keep it up, and is lifting some weights. Thanks, Elaine. I appreciate that. We have another one from Cable Box, who says, I'd like your opinion on the SCOTUS docket number 19-1257, Brnovich versus the DNC. Also, the word vetoed is used a lot in that case. What does vetoed mean in law? I don't know. I have to look that up. I don't know. I'm not familiar with that case. Mark Brnovich is here in the DNC, is here in Arizona. I sort of remember that lawsuit. I'm not sure that we covered that, though. Yeah, I'll take a look at it. If it's on the SCOTUS docket, I'll take a look at that. I'm not sure what it's being used in that context for, though. Thanks, Cable Box. I'll take a look, and I'll try to get an answer to you tomorrow. Thanks for a good question. Stumped me. I don't know what that is. All right, we have Greg David, who says, Trump and Bernie are true populists. Why they agree. Yeah, I think there's probably a lot of truth to that. We have Dirk Kessler, who says, what is the legality of an open-ended mask mandate at a state level? If no law exists, how can a state enforce fines, etc.? Well, the issue here is that they're actually passing the laws. So they're actually passing mask mandate laws. I've been following this around in Arizona for some time. Basically, what would happen is I think our different mayors pass their own individual rules for individual cities. And then in Arizona, we had a statewide executive order, which a mask mandate. We had county level mask mandates. And so all of the big tiers, right? You have the executive, the statewide umbrella, you have a county-wide umbrella, and then you have individual town umbrellas. And they're all passing various statutes. Some of them have actually, the legislatures have passed laws. The others have been executive orders by governors. And if the law is in effect, they can enforce them. They can fine you. They can do what they want. So, you'd have to address those at the appropriate level in order to address the law that you have in question. So open-ended mask mandate. I mean, I think they can pass it if they want to. They have. See where it goes. We have another one from Wolfgang, who says free speech includes symbolic gestures, correct? As such, perhaps the 2 a.m. use of a bullhorn is the free speech. Yeah, so the free speech example in all candidness was probably not the best one because free speech is very tricky. There's a lot of constitutional law surrounding that. So the bullhorn thing was just something I was just sort of riffing off of. But the Constitution or the Supreme Court has said that certain things, certain speech can be limited, and they talk specifically about time, place, and manner restrictions, right? It's the same reason that, when you go and protest outside of a Planned Parenthood, for example, you got to be a certain ways away from it, right? You can protest. You can't literally be at the front door of Planned Parenthood screaming at women as they're walking in the door, right? And by limiting you, by saying, nope, you got to be 1,000 feet away, you got to be on the other side of the street or whatever that looks like, that is a time, place, and manner restriction. You can't do it all the time. You can't do it anywhere you want. You can't do it in any manner that you want. Those are not limitations on your speech. Those are just limitations on how you speak. And because the laws are neutral, and they're applied generally, they're not singling out a particular sect like in the Cuomo lawsuit, Orthodox Jews. That is allowed because they're neutral on their face. We have Greg David, who says McConnell got $25 million from his father-in-law. Corrupt. Really? Yeah, that doesn't sound good. But that is a pattern that we see all over the place, right? Senators marrying into big money. Remember John Kerry was married to the Heinz ketchup heiress, right? Worth hundreds of millions of dollars. They just go, they have everything. Those families have everything. They need to go buy themselves a good senator. That's what they've done in that case. We have Aaron Seavey, who says, use of case law. Do cases cited have a general use or limited, like Fed equals Fed, only Fed equals Fed or state? Do cases carry more power, Fed or state case law? Great question. It's a complicated question. It's a little bit hard to answer. There are two types, or there are several different sort of classifications of precedent. And so what you want to look to is where you are literally. Okay, so I'm in Arizona. If I have a constitutional problem, I would look to first and foremost my state law, right? What does Arizona state have to say about this? Because I have a state issue. Okay, it's a violation of something, whatever it is, and Arizona law controls that. So I would look to Arizona cases to see how other cases have been dealt with. I wouldn't go to Texas and say, well, the Texans did this. Mine is an Arizona issue. I don't really, Texas can do whatever they want to do. That's not persuasive when I'm making my arguments in Arizona court. Now, I could say that, well, this is, if this is a new issue in Arizona, I could say, well, Texas handled this new issue in this way. Court, I think this is a pretty good way to do it. And what we call that is sort of persuasive law. Okay, it's not binding. The Arizona court can look to Texas and say, yeah, you know what, that's a pretty good thing. And that makes sense. And logically, it jives with the federal constitution. And so we're going to use that, but they're not bound by that. Now, what's a little bit different than that would be like, okay, well, now the Arizona Supreme Court is doing something, let's say, differently than California is doing something. So we're talking about the same underlying issues. Arizona's handling it one way, California's handling it a different way. Well, now the Ninth Circuit Court of Appeals, which is a federal court, which governs all of the Ninth Circuit, which is all the West Coast states, then whatever the Ninth Circuit says is going to supersede what Arizona wants to do. Okay, if it is a federal question, something that would bubble up to the federal court. And so, now the Ninth Circuit may be handling something different than the Third Circuit. Okay, so now we're working our way up. And now what happens? Well, the Supreme Court then decides. And so you've got all of these different tiers of case law and statutes, and some supersede others. Some are persuasive. If I'm making an argument in front of the Ninth Circuit, I can cite to the Second Circuit and say, the Second Circuit believes this. We think you should also adopt that standard, Ninth Circuit. But the Ninth Circuit could say, well, we don't care. Yeah, we're not going to do anything the Second Circuit does. We're the Ninth Circuit. Who cares? If the Supreme Court wants us to do something a certain way, we'll do it that way. But otherwise, it's not binding case law. It's not binding statute. So you want to, it's important to understand where you are and what arguments you're making. And it's going to be very, very specific to your particular question. It's a good one, though. Thanks, Aaron. We have another one coming in from John McClain, who says, the problem with restrictions is the lack of proof that restrictions do anything. Compare new case counts in Florida versus California. I totally agree with that, right? And I made this argument when we were talking about locking down the gyms. I kind of get spun up about this one too, but when we're talking about gyms, a lot of the allegation here was that, well, everybody's breathing hard. They're on treadmills and huffing and puffing, and they're touching a bunch of equipment and all of these things. Therefore, gyms should be shut down because they're COVID super spreader events. And I'm thinking, okay, well, if that's the case, I mean, if it is as obvious, certainly somewhere somebody has done a study on this, and they've identified that gyms have a tendency to spread virus more than any other place, more than a hair salon, more than a grocery store where you're picking up your fruit and looking at it, right? And then you're putting it in your mouth later. There are a lot of other places where people are doing similar things to a gym. Why are they not getting scrutinized to the same standard? And in my opinion, that would be sort of a violation of equal protection. We're treating one business establishment differently, giving them a bunch of options, but we're penalizing another business entity without any evidence that business entity, a gym, a place of worship, a Jewish Orthodox center, there's been no evidence that they are a higher spread vector than any of these other facilities. So if the law is punishing one segment and not another, that's not equal protection. The law is singling out one for punishment and supporting another one. And I thought that was a huge problem. And I think courts are coming into alignment with that. They're saying, listen, at the start of the COVID pandemic, we were going to have a little bit of leniency for you people. Shut down everything, it's fine. But now, 9 months later, you still want to shut this stuff down? You got to come up with some evidence. Otherwise, not going to hold up. We have another one from Wolfgang who says, the infected guy in a temple is not evidence for a religious restriction. Rather, it is an argument that also applies to Walmart mass congregation. Exactly right, right? I mean, what is the difference? If you have a gym, if you have a church, if you have a hair salon, and you're practicing the same restrictions or the same precautions, let's say, as any other facility, why should you be shut down? You shouldn't. We have Mr. Awesome who says, I really enjoy your commentary and look forward to your daily show. Thank you for your time, sir. Thank you, Miss Awesome, for your time. I appreciate you being here. Thank you for that nice compliment. I always like a little bit of support from time to time, and I appreciate you sending one our way. Wolfgang Deo says, drinking from the same cup is a symbolic gesture. That's right. He's talking about Catholicism, right? It's literally, in our belief, the blood and body of Christ. And, there's a lot of symbolism behind that. Thanks, Wolfgang. Paula MK85 says, love your show. Any updates on the Georgia signature audit that was supposed to conclude last week? I don't have one off the top of my head, Paula. We'll take a look at that. I was reading some Georgia headlines today. What was it? I think one of Lynn Wood's lawsuits over there got dismissed. He's going to be appealing it. There was another one that I had seen. The last update that I had from Georgia, I listened to some of the legislative hearing where Brad Raffensperger was on the call. It was just a big pat yourself on the back thing. As far as I could tell, everybody, we did a great job. We checked everything. Everything's perfect. That's the last I heard about it. But if there is any conclusions from the signature audit, we'll make sure to cover those on the show. Thanks, Paula. Appreciate you being here. Another one from Wolfgang. This is not smallpox. With a 99.7% survival rate, it is best for us to not restrict the virus's spread. By spreading, we gain faster resistance. That comes from Dr. Wolfgang. Thanks, doctor. That Popo was lamenting free speech. Yeah, I mean, truthfully, I understand how frustrated people are. I'm not so sure that criminalizing that type of speech is necessary, right? Truthfully, I mean, if I was in that room with the cop, I'd probably go, yeah, he's just pissed. He's pissed. Somebody's talking about taking his job away. Somebody's talking about literally eliminating his livelihood. This officer, to my understanding, had been practicing on the force for over 20 years. He's on the verge of retirement, or I think he's getting a retirement as he's still on the force. So he's been doing it for a long time. Somebody is threatening your business. I have a lot of empathy for the guy, right? They're saying, we're going to defund the police. He's going, what? Like hell you are. Okay, this is my life. I empathize with that. The same way I empathize with businesses that are being shut down by the government across the board. I empathize with people blocking the cars of health inspectors like we saw in LA saying, I'm desperate. If I can't work, you can't work either. I understand that. I get that people are frustrated and venting they're airing out their grievances, which is okay in my book. When it crosses the line, when somebody doesn't act in furtherance, like we saw out of Michigan, when those 6 individuals were literally scoping out Governor Whitmer's house, they said that they were going to take her out. Then they did something in furtherance of that. Whether they were going to do it or not, I don't know. But now that they took a volitional act, they took one act in furtherance, that's enough in my mind. This cop just saying that he was going to, shoot her, it's not good. It's concerning. Not sure he should be a cop if he can't control his speech like that. But should we throw him in prison for that? Was this really a terroristic threat? Probably not. Okay, we've all said dumb things like that before in our lives. Doesn't mean that we meant them. Okay, I've said many, many times, I'm going to drive my car off this cliff. I'm going to jump out the window right now. If you keep talking, I'm going to literally jump out the window. You know how many times I've said that? A lot. I never did drive my car off the cliff. I never did jump out the window. Even though I said it. I'm sure this cop wasn't going to go shoot the mayor. Still shouldn't have said it, though. Thanks, Wolfgang. We have Aaron Seavey who says, state law or local ordinance in AZ, which is used when charged, can both be used against when a person is charged, or can it help you with using a defense? Another good question, Aaron. Going pretty granular on some of this state law stuff. So once again, it's going to be similar to the last answer. It depends. So in Arizona, we have Arizona revised statutes. Okay, right now, if you get charged with a DUI, it's going to be under Title 28, whole different slew of statutes there that applies all over Arizona. So we don't have individual DUI laws for the city of Scottsdale, for the city of Mesa, for the city of Glendale, for Phoenix, right? We don't. We have one unified set of statutes. But individual cities also have their local city ordinances. So, for example, in Scottsdale, they criminalized driving a scooter drunk. Remember those electric scooters? They used to be all over the place here. There's not so many of them anymore. I think they didn't make any money, but they criminalized that. We had a lot of people in our old town part of Scottsdale who were driving around on scooters drunk. It's kind of the whole point of the scooters, right? So you don't have to drive a car. And people were going from bar, hopping between the bars, having fun, not being responsible, not driving a car, driving an electric scooter, something that's not going to kill anybody. And Scottsdale got tired of it. So they passed a local city of Scottsdale criminal statute that says if you are driving a scooter drunk, you get 5 days in jail, just like a DUI. But the rest of the state of Arizona didn't have those laws. So once again, you can see different rules at different levels of government. We have a statewide umbrella. We have individual city umbrellas. We're seeing that again. Arizona just legalized marijuana across the state starting next year. Well, even though Arizona legalized it, we have a lot of different states who are sort of carved out. They can have some exceptions. They can make their own individual rules. And many of the states are criminalizing possession of marijuana anyways. Okay, the state legalized it, but individual cities, I think Scottsdale is one, Glendale is one, Gilbert, I think, is another one. They're all passing, their city councils are passing their own rules saying, nope, marijuana is not okay here. So we're going to have a lot of conflicts about that. Looking forward to that. We have another one from Wolfgang. We have Wolfgang Deo says, Rob, you have to watch your use of blowing it up. I could be a little bit more clear with my language. I certainly agree with that, Wolfgang. Greg David says, use XLEAR spray. Also, it takes 2 days to be symptomatic. We have Wolfgang says, Rob, please tell us more of what we do not want to hear. As for who to turn to, I never turn to anyone but Jesus. Thanks, Wolfgang. We have another one from Shifra Morgan. Says, absolutely love your show. Thanks, Shifra. I am very fearful as to what 2021 will be like. I say 2020 felt like I was definitely dealing with my 20-year-old, and now I am like, great, let's add some alcohol. Yeah, I know. Yeah, 2020 has been a heck of a year. You know, I know a lot of people are fearful about 2021. I'm not particularly. You know, I think that America's resilience. I think that if you are living well in your life, remember, you know, politics is not life. It feels like it. Feels like every day because the government is so intertwined with our lives that anything that goes wrong in the federal government, it means that, you know, it's our personal problem. Congress can't pass a bill. Oh my gosh. Is the world really falling around you? Probably not, right? Most of us who are living in America, most of us have mostly first world problems and things are okay. And so I'm encouraging, when I say that, when I sort of say stuff like this to you, I'm really talking about myself. You know, I'm really sort of giving myself advice live on the air. It's me saying, all right, listen, politics is not life. Let's separate out a little bit. Let's remember what's really important. Family, right? I've got a big vision for what I want to do with my firm, my career. I have a lot of people that I want to help in this world. Can I do that even though Congress is sending $2.4 trillion dollars Yeah. Does it really, really piss me off? Yeah. But I can keep it together, right? I can keep moving forward. I'm not going to let any outside sources really knock me off my game. I mean, that's my plan for 2021. And, you know, I'm going to get frustrated. Certainly, I'm going to get angry about things. But I think we're going to be just fine. We're all going to get it together as long as you have sort of a bigger purpose with your life. If you need help identifying that, you know, that's a separate conversation. But, you know, when I think there's a lot of people in this country who are hurting very badly because they are so identified with one particular candidate or one particular party or one particular concept. They sort of define themselves by that. And that's troubling because are you really living your own life or are you living that person's life? So with a little bit of distance between, you know, how we operate and the rest of the world, I think we'll all be a little bit better off. And if 2020 gave us anything, it's a little more distance. So we'll see how it works out. Thanks, Shifra. I really appreciate the show. So glad that you're here watching us. And we'll make 2021 great. I promise. All right. We have another one from Dustin Collins who says, based on the evidence presented to this point, do you believe that fraud has been proven beyond a reasonable doubt, or is it a lot of smoke, but we haven't investigated the fire properly? So it's a great question, Dustin. And we sort of got into this. I think I talked about this for 20 minutes last night on Uncivil Laws channel. We really kind of did a deep dive on that. Long story short, right? All of the claims, all of the lawsuits that we have seen brought thus far, I think a lot of them have not been heard on the merits. Most of them have been dismissed for other reasons, you know, mootness, standing, ripeness, latches, all sorts of stuff. And we haven't really seen a good case, I think, strewn out in front of the courts. Seen a little bit of that with some audits in Arizona and some other parts of the country. But, you know, largely, I think the election fraud allegations just haven't really been laid out on the table. All the cards haven't been laid out. And there's been a lot of pieces that Trump's team has put forward. I think some of the more interesting claims have been brought by other attorneys who are really sort of focusing in on some of the constitutional divisions. I think the constitutional divisions are the more interesting claims here, and I think those have absolutely been proven, right? So, when we're talking about allegations of voter fraud, yes, there's a lot of affidavits saying that there were some problems, a lot of those, a lot of information about it. But the issue here, and the issue with this question, it's not to attack you personally, it's just sort of it's a difficult question to answer here, because you're trying to sort of conflate two things. You can say, yes, there was voter fraud in this election. I think that's without question. I think beyond a reasonable doubt, there's absolutely voter fraud. But the remedy that has been requested in many of these lawsuits doesn't match the harm that has been alleged. So, for example, they're saying, let's say pick a state. Okay, 10,000 votes were illegal. All right, great. Well, what should we do? So they file that claim in court. They have a lot of evidence to support that. Courts don't hear them, but let's say they did. And the court says, you're right, there were a lot of problems with this election. What do you want to do about it? Well, the Trump's team says, well, you got to throw out all of the mail-in ballots. Wait a minute, that doesn't really make sense. Why? Because you didn't observe those ballots being counted, or you don't think the signatures matched? Okay, we agree that these are problematic, but how are we going to extrapolate this harm that you specified in your lawsuit to literally, all of the mail-in vote? We're talking millions of votes. So they haven't done a good job of connecting those two things. So while we can say, certainly, I agree that there were a lot of problems with this election, I think anybody with any sense, anybody who says that there was no fraud in this election is just lying to you, right? We've got enough documented evidence about it. Is it enough on the face of the evidence that has been presented to change the course of the election? I don't think so. I think the harm has not been appropriately tied to the remedy that is being sought in the various courts. Now, the bigger issue, and I spent some time last night on Civil Law's channel talking about it, is this idea here that the Democratic Party, and a lot of the big money institutions were changing the rules of the election before the election. And you can go back on our channel before November 3rd. We were talking about all this stuff. We covered a number of different cases. I was very critical of the Supreme Court when they declined to step in on the Pennsylvania case before the election. I said there's going to be a lot of problems with this after the election, and there are, right? We all saw this, a lot of attorneys maybe didn't look into it, but I saw it coming from a mile away. It was obvious. The Democrats were filing lawsuits all around the country. They were literally trying to change the rules of the game right before the game started. They did so. They were successful around the country. The Republicans were caught flat-footed. They didn't respond. And I think what they did is they just changed the underlying nature of the field in a way that grossly advantaged them. And they won the election. And if you go back, you can look at the lawsuits. I mean, they did. Pennsylvania, the DNC was suing Kathy Boockvar, who is also a Democrat. We had the Michigan Alliance of Retired People suing Jocelyn Benson, also a Democrat. So they were suing each other and entering into these settlement agreements or resolving cases that changed the rules to favor them. That is the malfeasance. That is the fraud, right? They were changing the rules at the last minute, and the types of I think allegations that were taking place there, or that I saw most issues with, were some of these constitutional divisions of power. So it was less about, signature matches. It was more about a court just extending the election deadline by 3 days on their own. Legislature didn't do it. Governor didn't do it. The courts just did it. Well, the court doesn't have the power to do that. That is a power that's reserved for the legislature. The Constitution says the legislature conducts the elections, runs the elections. They get to decide how they're handled. Courts just changed everything on their own. That, in my mind, is a separation of powers problem. It's a constitutional problem. And that, I think, led to a lot more of the election malfeasance than any, particular bucket of votes. I think that is the bigger issue. And I think I can say unequivocally, beyond a reasonable doubt, that happened, because there are court documents indicating as such. Mark Elias over on Twitter and, Democracy Now, I think.com. I mean, they've been a lot of money, a lot of lawsuits, a lot of effort. They are well suited. Okay. The Republicans, by contrast, it's like in World War II when, Hitler was rolling into Poland with his tanks, and the Polish were on their horses and buggies or whatever, whatever that story is. And just totally outclassed. Legally, the Republicans got obliterated. And if they don't change course, they're going to get obliterated again. the next go round. We have DJ Fish Official says, from Kyle Becker, McConnell has introduced a competing bill that would repeal Section 230, set up a commission to study voter fraud, and increase COVID relief payments to Americans from $600 to $2,000. Wow, okay, so there's something, right? That's something. It's not bad. We'll see where that goes. At least he's going to do what he says he did. I mean, if that's accurate, Kyle Becker, I'm not sure who that is, but yeah, you would certainly expect McConnell to do something. Study voter fraud, increase COVID payments, repeal Section 230. I'd also like to see a major cut in that pork spending. I'd like to see that $2.4 trillion come down to as low as we can get it. That would make me a happy camper. We have Wolfgang Deo who says perhaps the leftists in power are trying to get apolitical people to finally inject themselves into politics. Unsure. Yeah, we'll see. I mean, I think they benefit by keeping people uninterested in politics. Okay, most people that I talk to, when they have criticisms of Donald Trump, it's not a policy criticism, largely. Maybe your experience is different, but it's mostly about the idea that he's a racist, right? Or he did something to a woman in a locker room sometime, or, it's one of those types of claims. And you say, well, what about this? And what about that? And what about, tax cuts and a booming economy and low black unemployment? And, he did those things. What about Operation Warp Speed? Does anybody know about that? That was a Trump thing. But mostly the criticisms are about stuff like racism and stuff like that, which I think are, I'd say, uneducated criticisms. We have another one from Brian Kang. It says, hey, you back, Brian. Good to see you. Thanks for the support. We have Wolfgang Deo says, I believe age of consent is a general establishment rule. The issue is consent and who cannot give it. Typically, people are taking advantage. Yeah, so I mean, in most states, to my understanding, again, I can't speak for all 50 of them, but you are incapable of consenting if you're under 18. You cannot consent. So if you're 19, you have sex with a 17-year-old, the 17-year-old consented? No, they didn't. They're not capable of consenting. So you can't use consent as a defense because they don't have it. They're a minor. They can't consent for themselves. We have Theocratic says, can we all appreciate the white pill that voters have rejected the establishment? The old guard repubs are dying and the realignment is taking place. Cheers on that one, my friend. I agree with you. I have no interest at all of having anything to do with McConnell, Graham, Howley, any of those guys, right? Because they're all just they're Democrat light. And honestly, I'd rather have Democrat, the real thing. Okay, if I'm going to drink a soda, I'll take the real thing. I don't need the diet. Give me the real thing. Not that I like their policies, but if the country wants, if we want to see what it looks like, let's see. Put it on display. Let's see what they do. And let's see how people like it, because that will force a realignment. Rather than this slow bleed, death by 1,000 cuts, Republicans are Democrat light. They're all wishy-washy. They all want to tax and spend the hell out of us. Nobody wants to accomplish anything. They're all bought and paid for, owned by the Chinese. It's the same story with just two different names. They're all pals. They all hang out. They all fist bump each other on the Senate floor. So I'm okay with the retirement, let's say, of the old guard Republicans, and it's time for some new, fresh blood in order to realign or remind America about what made this country great. It's not big government. Not at all. We have Sabo Abbas who said, is anyone concerned about the national debt now around $30 trillion? No, apparently not. Apparently not. Nobody cares. Congress just added another $2.4 trillion. Not even a big deal. And this is one of my criticisms of the Trump administration. He didn't do anything for spending. Almost nothing. I mean, the budget was blown out just like the Democrats did. It's concerning. Wolfgang chiming in again says, the government provides a service. When are they going to get taxed for their services provided? Well, the government exempts themselves from everything, right? Like with Obamacare, Congress didn't have to comply with that. They have their own health care. It's just for you. It's just for the little people. Take it and be glad that you got it. We have Wolfgang says, case law needs to be revised in accordance with the Constitution. Sounds like this is giving rise to the bloviation that is rampant in Rona 2020. Yeah, I would agree. There are a lot of laws, I think, that are not in alignment with the Constitution. We're seeing that across the board, largely in the election litigation stuff. But the courts have just said that's okay. You can do whatever you want. Run your elections however the hell you want. Nobody cares. Wolfgang Deo says, science and laws have the same kind of silliness going on. Someone does a study or judgment, and people take precedence from bad precedents. Yes. Okay. Thanks, Wolfgang. We have another one from John McClain says, can equal protection be used when churches are allowed and gyms are not allowed? So my argument, as you just heard, John, would be that, yeah, you can, but gyms have you can make the same argument, but the standard of scrutiny is going to be different because going to the gym is not a protected constitutional right, even though it should be, but it's not, right? Practicing religion is something that is very, very coveted. It's in our First Amendment. There's no amendment to, allow you to go to the gym. There should be. Maybe I'll sponsor one day, but we're not there yet. So it's a different standard. So the government would have a lot more leeway to close down a gym than they would with a constitutionally protected right, like you would see when it comes to practicing your religion. They did try the equal protection argument here. There was a gym here by the name of Mountainside Fitness. The CEO of that company was my personal hero back during this time, and he was very aggressive, and he sued our governor or some entity in our government and was saying that equal protection was a major part of the claim. And ultimately, I think the courts found the governor could do whatever the governor wants to do because that's what the courts do. Government looks into itself, finds we did nothing wrong, no problem. We have another one from Aaron, says, Rob, with social media and people posting so much, would it be wise to state, in my opinion, when posting about hot topics, or does it not make a difference? So Aaron, I think it doesn't matter in most situations. If you're going to be making personal claims about another person, or you're getting close to saying somebody did something, then that might be a good time to use, in my opinion, right? In my opinion, basically what you're asking about is can you be sued for defamation? Can you be sued for libel or any of those things? I'm not a defamation lawyer. What I sort of expound on comes from my remembering back to law school days. But if you're talking about a public figure and you're just sort of opining about, your opinions on that person, what they did is stupid, this person's an idiot, you're allowed to do all of that stuff. They're public figures, and they're within that, the court considers them to be playing in that arena. If you're going to be a public figure, you got to take it a little bit harder than the next person. And so in order for somebody in the public eye to sue you for something like that, like defamation, they would need to show that you were defaming them, meaning you were making false statements about that person, and you were doing it with actual malice, meaning you were literally trying to harm that person. I said that about that person with the intent of harming them, which is a pretty high standard, right? So if you're just commenting on the news and you're commenting on, politics, I don't think that's problematic at all. If you're going to be, going after somebody, let's say like a local business owner or somebody who's on a lower scale, and you want to go on Facebook and post something that's not true about that person, or let's say it's questionably true, you could say something like, in my opinion, this is what I think is going on, rather than, and that's really what it's doing. It's preventing you from making a definitive fact statement. You're saying, in my opinion, this restaurant puts that in their cookies and that's awful, right? Rather than you saying, in my opinion, or rather than you saying that restaurant does something like that, which if that's not true, it's a defamatory statement about that restaurant, they could be very upset with you and file a lawsuit. Are they going to do it? Probably not. It's expensive to file a lawsuit. Are they going to get any money from you if they win? I don't know. I don't know what your assets look like. If you have a lot of investments, if you have a lot of personal, assets that might be attractive to somebody filing lawsuits, then yeah, you want to protect yourself a little bit more. But, it's one of those things that is, I think it's just in general, it's just good to be sort of respectful in your conversations. I tell everybody here at our firm that, every comment, every phone call, every email, every text message at some point could come under the eye of somebody, some judge, some cop, somebody somewhere, you don't know. So I just encourage people to be careful with their speech. If you read the book, The Four Agreements, the first rule, I think it's the first one, is be impeccable with your word. Your word is very, very important. You want to be clear and concise and direct with your speech. So try not to use loose language when it's not befitting of the situation. Good question, Aaron. Another one from Christy Anthony says, love your show. You're very educated on the law and you have an enjoyable sense of humor that adds to it. Thanks, Christy. Sometimes I try not to be like a robot on here and have a little bit of fun. Thanks for noticing and for the feedback. We have quo warranto is an old common law writ to challenge an official's right to hold office. Sometimes it has to be approved by the AG, depending on the state. So World War, what you're talking about is old common law stuff, which is it's old. It's common law. Most in the United States, and I'm sorry if I didn't answer your question fully the last time around, but in the United States, most of our rules have been codified into statutes, which means we don't lean on the common law anymore. We look at case law. We look at individual statutes. So if we're going to be asking about a DUI, we look to the DUI statutes. It's codified. It's there, right? It was revised, I don't know, 10 years ago, wherever you are. It is new. Common law is sort of an old. When the law was young in the United States, we would look back to common law. We would say, okay, well, what did the English do with this? How was this dealt with in an earlier era when we were talking about codifying and developing our own statutes and constructing our own way of self-governance? And so what you're talking about, yes, you can go back and you can find references to it in old common law, but if you brought that into a court of law today, what they would do is they would just say, okay, that's fine, that's common law, but that's not applicable anymore because we've codified the rules. If you want to remove somebody who's running for office, well, you have to go and you have to file a recall petition and you got to go through this format. What you're talking about removing somebody from office, there are formal mechanisms in place and the courts would just refer you over there. They'd say, you want to pull that person out of office, go do it. But I just don't see a lot of ability to lean on an old common law doctrine and see success in the modern law courts. We see this sometimes with some people who consider themselves to be like sovereign citizens and things, who say, well, I didn't agree to abide by those laws, and the courts just say, okay, well, you're in Arizona, you're in Florida, and you have to have a driver's license. I don't care if you don't think you need to have one, but you do. You might think you're a sovereign citizen and that you can travel around in interstate commerce without being intruded upon, but you're in Florida. We require you to have a license. It's in this statute right here. You're referencing common law or sovereign citizen doctrine, whatever those look like. And the courts just say, that's great. Nice argument. We don't even care about it because the modern law tells us to deal with it differently. Another one from LD 2020 says, would the case that is being brought against Sidney Powell for defamation by Dominion give Powell's team access to their machines? Good question. So I haven't seen an actual lawsuit. I think that the argument there would be yes, that Sidney Powell would respond and say, okay, you're suing me for claiming that I made a defamatory statement about you. You're suing me saying what I said about Dominion is unlawful, or I'm sorry, is not accurate. It's false. Well, I believe that it's true. Here's my evidence. If you have other evidence that would purport to undermine my claim, let's see it. Open up the books. Let's see what you got. And, Dominion, I think, would be hesitant to engage in that. The only lawsuit that I have seen thus far, doesn't mean I haven't missed it, but it was filed by a Dominion employee. So you see what they're trying to do. They're trying to, one step removed from their company. So the employee, or I think it may have even been a former employee, so that when that comes back, that employee will say, I don't have access to any of that stuff, right? I can't give you that information. But certainly, if they're going to sue her, she's got a right to demand discovery back from the people who she's being sued by. We'll see if that happens. S. Love says, why are so many Americans so complacent and lazy? They complain, and do nothing to stop the BS. Can't agree with you. Lost the Senate will equal a lost country. You know it. National strike. So S. Love is not in agreement with me. Cannot agree with me. I certainly don't want to lose the Senate, as I think a divided government is a better form of government. If the government doesn't do anything, that's better than them passing $2.4 trillion spending bills on 2-hour notices and funding the rest of the world. I would be okay with no bill versus that bill. So if we have a Republican Senate, a Democratic House, and a Democratic executive branch, and a conservative Supreme Court, kind of a split government, I'm okay with that. The idea here that the Democrats get the Senate, the House, and the executive, that would give them the power to pack the court. They could literally take the entire country into one-party rule. I would be very, very problematic. I would be very concerned about that. So S. Love, I think, is on the right track that we don't want that to happen. Even if you're a Democrat, I'm not so sure that you want that to happen. We have Dustin Collins who says, I should have rephrased it, but you answered it. Did the evidence of fraud, changing of the votes, support the request to totally change the election? Great answer, though. Yeah, thanks, Dustin. Yeah, I don't think so. I mean, the short answer on that is no. They brought a lot of evidence into court. Was there enough there for a judge to say we're going to reverse Pennsylvania? I don't think so. I just don't. And we've analyzed probably, 20, 25 different lawsuits on here. A lot of them have been very good. And I think the better arguments were not by identifying, buckets of votes that should be thrown out. It was more about saying, well, look, the Pennsylvania court changed the election by 3 days. Anything that came after that unlawful change, that unlawful extension, should be thrown out. I'd be more inclined to get in line with that argument. It's a very good question, though. We have Mandy Watson says, how can we stand up to corrupt media other than stop watching? So, on this one, I would encourage you to start becoming the media. I mean, literally start broadcasting, start writing, start conversing about some of this stuff, reading, start a YouTube channel, start a Rumble account, hop on Twitter, start being a little bit more vocal. I think largely, and myself included, there is more that I could be doing, and I'm going to be thinking a lot about that in 2021. How can I sort of do more? I'm always looking to up level things around the board. And I think that, there's a lot of Americans right now who are patriotic. They've been they're emerging from the cocoon of being a Trump supporter, right? Many Trump supporters have been in hiding for a long time, right? And I don't know how many of you felt that, but there's been almost a very, very loud negative backlash for anybody who comes out and supports the president. Business-wise, politically, personal relationships even. And many of them have been in hiding for a long time. And so now that it looks like maybe that era is over, maybe it's time to be a little bit more vocal, to speak up, to familiarize yourself with some of the old texts, the Federalist Papers, Common Sense, John Locke, Edmund Burke. There's a lot. And once you can educate yourself and you can communicate about it, then you can help wake up other Americans. Many Americans are just in a slumber from COVID. They're in sugar, alcohol, drugs, and Netflix comas from the last 9 months. And so, when the government is becoming a little bit overactive, overly encroaching, the pendulum swung one way because of COVID. People were petrified. They were looking to government for answers. But now that is sort of swinging the other direction, I think a lot of people are going to emerge from their cocoon and be very disgusted by what they see and how they're expected to live their lives. I'm hopeful that maybe there is a new alignment, a new sort of awakening of real, true, genuine American principles where we're talking about freedom, we're talking about self-governance, autonomy, less reliance on the government, more personal responsibility. We don't need the government to solve every problem for us because when they try to solve problems, they just make it worse. Let's think locally. Let's bring things back into our own homes, our own universe, and stop worrying so much about what these politicians in Washington are doing and pull some of their power back, quite frankly. I really don't think that we need them to do all the things that they claim that need to be done. Thanks. We have Pinky who says, we need term limits. I support that too, Pinky. I am tired of these people who've been in office for 40 years. Joe Biden is one of them. We have Wolfgang Deo who says, defunding the popo is not just them losing their jobs. It is causing danger to society by removing the extension of justice from the streets. Yeah, it's causing danger to society by removing the extension of justice from the streets. Yeah, I've not been in favor of defund the police, right? I think law enforcement has a very valid, legitimate basis in our society. Defunding the police is ridiculous, but I don't think it's going to go anywhere. Greg David says, NTD has a lot of new witness videos out now. NTD, I think they're affiliated with the Epoch Times. I like that website. We have another one from TZ 1052 New York says Lincoln Project. Now the R party is dead. One half the country feels they have no right to be heard. Korematsu is their legacy. Why should we bother voting? Well, because that's the system that we live in. If you don't vote, you're not even playing the game anymore. You're just kind of resigning yourself to defeat. And I know that there are some people who just are apathetic and they just sort of are out of politics. There's some freedom to that, right? If you just live your life and don't have to worry about what these politicians are doing, you just go with the flow. There's some freedom to that. I'm kind of envious of that, actually, right? It'd be kind of a nice, ignorance is bliss, right? Kind of a nice way to live. But alas, I don't live in that world. That's not my personality style. I do think that there's a lot that we can do. And I think voting is one of those things, right? Even though the system is imperfect, it's the system that we've got. And the way that we can exercise our voice is by voting. And as I said, on a national level, there's a lot of questions about the integrity of our voting systems, whether they work, whether they're as foolproof as they all claim them to be. But locally, I think you have a much closer level of representation between you and your local state representative, your local state senator, and you can impact how your local governance functions. I'm encouraging people to run for. People should be running for office. If you don't want to vote for someone, go run, right? You go run, and you get to be a part of what that election looks like. Thanks, TZ. We have another one from World War Wit, who says 2010 Georgia Code, Title 7, Practice, Chapter 6, Extraordinary Writs, Article Quo Warranto. So there we go. So look, this is the power of the internet. World War Wit, go. I say, hey, there are statutes out there in place, so you can't rely on Quo Warranto. He pulls up the statute right out of Georgia. There you go. So it's in the Georgia statutes in 2010. Don't know how updated that is, and don't know what it says, but very interesting, World War, and I appreciate it. Thanks for educating me. I'm not familiar with that stuff in Georgia. Haven't seen anything like that in Arizona, but doesn't mean it doesn't exist. So thank you. I'll take a look at that on the next one. We've got another one from Wolfgang, says, when is Trump going to pull the ultimate Trump card, the Washington card? I think he has been going up and down the Delaware when golfing. Yeah, I'm not sure what card you're referring to there, Wolfgang. I think if he had a card, he probably should have already played it at this point. We have another one from Wolfgang, says the blue coats are coming, referring, I presume, to the Democrats. We have LD 2020 says, can the Navarro report be used as evidence by a House and Senate member to nullify electoral votes and lead us to a contingent election? So, yeah, LD, I think absolutely they can. My understanding is there's no formal rules of evidence that would take place when the House counts the electoral votes. So I think a senator, a House representative person could object on any basis that they want. I don't think they need to lean on anything. If they were going to be leaning on the Navarro report, I think it's a pretty good report. We covered that on this channel. We went through it, kind of slide by slide, and broke that down a little bit. And it's as compelling as anything, right? And if they wanted to lean on that, they could do that. I think the bigger question for them would be, does that give them enough political cover to do what they want to do, right? They're all going to have to point back to something in order to justify their vote, because when they go back to their constituencies, there's going to be a lot of people who say, well, you just, you're promoting this electoral fraud conspiracy, and now we're angry at you and we're not going to vote for you the next election. So they have to be able to address that concern by saying, look, I know you don't think that there was election fraud, but here's why I do, and here's the evidence that I was leaning on in order to cast my vote. So it's less of an evidentiary thing. I think they can lean on anything they want. You could probably have a senator who just walked out there who just said, I don't like Joe Biden. I think this election was fair as hell, but I don't like Joe Biden, and therefore I'm going to object to the votes. I think they would have a legal basis to do that. Now, they'd probably get skewered when they went back home, but might be worth it for them. We have another one from Christy Anthony. Do you think term limits will ever be possible? I don't think so, Christy. Unfortunately, same reason I don't think that Section 230 is going to have anything ever really meaningful done to it. I'm hopeful that they will. I'm hopeful that term limits would be in power, be in place at some point in time. But why is Congress going to do anything that limits their power? They just won't do it. And if we wanted to amend the Constitution, we need some of the Congress, and we need 3/4 of the states. We need a lot of political willpower in order to get that done. And, Congress, they want to be in power for all eternity. So why would they limit themselves, right? Why would why would you turn down a $2,000 check over a $600 check? Okay, most people wouldn't do that. They're going to take what they get, as is human nature. Another one, last one from Wolfgang Deo says, I do not say it enough. Keep being awesome. Thanks for being here, Rob. Thanks, Wolfgang. That's a nice way to end the program. And thanks for that. Wolfgang, very active. Wolfgang is really help and support the show, and we appreciate that, Wolfgang. I'm glad that you're here as well. And so that's it, my friends. We're going to wrap it up right here. I want to invite you right now, if you've not already done so, to join us. We go live at this time every day of the week. A subscribe would be awesome. It keeps us motivated. I love seeing those numbers go up. We're almost at that 6-figure number, which is super exciting. I hope we can get there. And so I'd love it if you subscribe to help us reach that goal. A thumbs up would be awesome. Helps us sort of escape that YouTube bubble that they put around us when we talk about politics. And so I'd appreciate a thumbs up, a comment, a share. Invite your friends, invite your family members to come and join join us in this conversation. We have nice civil conversations like friends around the dinner table. And we want more people to be here and join us as we go through that. The slides that we went through today are also going to be available on our Discord server in our chat right after the show. Miss Faith is right back there. She's going to clip those all up and throw those in there so they're accessible for you. You can also get a copy of my book in there as well, which is this one right here. It's called Beginning to Winning: How to Fight Your Case and Succeed in the Criminal Justice System. And, it's mostly for people who've been charged with a crime, but it's got a little bit of an introductory paragraph in there, a chapter. Tells you a little bit about my story, some of the things that I've been through, some of the ways and reasons why I think the way that I think is in there. Talked a little bit about it last night on Civil Law's channel. One more plug for him to go check out his channel. He's got a good channel over there. Also talks a lot of law. So if you're interested in this field, go give him a subscribe. And lastly, but not leastly, I want to invite you, if you know anybody in the state of Arizona who has been charged with a crime, hopefully you don't, but if you do, we'd appreciate a referral over to our firm. That's what we do. I do this show, but my day job is a criminal defense lawyer. We've got a team of over 20 people here. We've built an awesome law firm with the best team, I think, in the state, if not the country, where we're very passionate about helping good people get things back on track. We're very good at what we do. We're very aggressive. We offer free case evaluations. And so if you would do us the honor of sending someone our way, that would mean the world to us. We'd be very grateful that you would place your trust in our team to deliver what I'm telling you will deliver. And that would be the ultimate compliment, truthfully. So that's it, my friends. Other than that, I do hope to see you back here again tomorrow. We're going to be burning through this week. We're not taking any breaks for New Year's. We're going to go into 2020 strong with a bang. We're excited. We want you to join us for that. So the show goes live every day. It's 5 p.m. Arizona time. It's going to be 4 p.m. on the West Coast, 6 p.m. Central over in Texas, and then 7 p.m. on the East Coast. We want to make sure that you are here with us so that we can continue on this conversation. I want to wish everybody a very lovely evening. Have a wonderful dinner if you have not had that already. Sleep well. I'll see you back here tomorrow. Thanks again. Bye-bye.